Hey, please, Lordship. Lordship, I am preparing for item number 21, my lord. This may be urgent for 10 days only, my lord. Because brief is misplaced in my senior's chamber. That's why, my lord.
21.
21, my lord.
You're for the
Appellant, my lord, for
appellant.
insurance company, my lord.
Why MSC appeal has come before this court?
Pardon, my lord.
Why insurance appeal before this court?
Some
And speak.
appeals is given different courts, my lord. That's why, my lord, for hearing, my lord. 2 to 3, my lord. Some items given, my lord.
Okay, your good name.
L. Sharma.
Miss L. Sharma, learned counsel for the appellant, submits that she has misplaced a brief and therefore she requires 10 days time to locate and prepare the case. Accordingly, matter stands adjourned for 10 days.
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 19 and 20, your lordship. Lordship may kindly adjourn the matter for the day, your lordship.
Why?
Lordship, my senior Mrs. Agans is engaged in another court, your lordship.
Hey, Gayan, you're for the respondent.
Your lordship.
Have you informed the other side?
Yes, your lordship.
Miss A. Gayan, learned CGC, appearing for the respondent Union of India, is said to have some personal difficulty to appear before the court today. On a prayer made on her behalf and not objected to by the other side, matter stands passed over for the day.
Lordship.
May I please, your lordship? I beg to mention for item number 6, lordship, admission column, lordship.
Hmm.
In this matter, the respondent has filed affidavit in opposition, lordship. We would like to file a reply on that, lordship. Kindly grant us a three weeks day,
Yes,
3 weeks time.
3 weeks time is granted to the petitioner, file the journal affidavit. List again after 3 weeks.
May I please, your lordship?
Deeply obliged.
Mention one read petition for listing. The similar matter already decided by the division bench, madam. And on the last occasion, we sought time for filing an additional affidavit. Today we have already.
When was
filed,
it last listed last?
In the month of June, madam.
June.
June.
Give a date.
Obliged.
Yeah, please, your lordship, may I request lordship to call on the record? We have filed our affidavit, additional affidavit on Friday, item
Which is?
16, item 16.
16,
Yes, lordship.
additional affidavit
Yeah, maybe call for
for
lordship.
the filed by whom?
Petitioner,
Okay.
obliged.
Affidavit.
May I please, your lordship?
Hmm.
I beg to mention item number 26, your lordship. The standing counsel of Mr. A. Sumo is unable to appear before this court, citing some personal difficulty today. Your lordship.
26.
Item number 26 only.
Who cannot appear?
Citing counsel ASTC, Mr. A. Sumo.
Who?
Mr. A. Sumo, your lordship, standing counsel for the ASTC.
It's a more.
Yes, your lordship.
So what do you want?
Your lordship, any date, may we please?
Have you informed the other side?
Yes, we tried to contact them in the last time.
For the petitioner, any objection?
So kindly fix a date of petition, your lordship. Kindly fix a date.
Mr. A. Chamwal, learned standing counsel, Transport Department.
ASTC, your lordship. Assam
Okay,
State Transport.
appearing for the ASTC. The respondent is said to have some personal difficulty to appear before the court today. On a prayer made on his behalf and not objected to by the other side, matter stands adjourned. This the matter again. It's September 2026.
Wait, please, your lordship. The consent of other side, I beg to, with the consent of other side, I beg to mention item number 27. Today, my lord, the engaged senior counsel, Mr. Ndeka, is having certain difficulties. So matter may kindly be adjourned.
Mr. Ndeka, learned counsel for the petitioner, is said to have some personal difficulty. Conduct the case today. And on a prayer for adjournment made on his behalf, matter stands adjourned.
Any other, any date may be.
Give a date in September. On 10 September. Mr. Deka is a senior counsel, isn't it? Good senior counsel.
Lordship, I beg to mention item number 28 and 29, Lordship. Matter may be passed over for the day, Lordship.
All the hearing matters are getting adjourned. Why?
Lordship, some.
Why do you want Passover?
Lordship, My senior is actually not here in present lordship today.
He is not present, so what? He should be present. You are engaged to be not present or what? Or are you engaged to be present?
Lordship, one more day, lordship.
No, tell me. When you accept a brief, is it for not presenting yourself or not to being absent? What is the difficulty? You tell me. Who's your senior?
Deep Ukasta, lordship, is a bit of medical emergency, lordship. If possible, he may come, he may not come also, lordship. But so
Before you make a mention, please make up your mind, okay? Don't give me 2, 3 reasons. That creates doubt on the bona fides. Mr. B. Procastel on it counsel for the. What about, okay, he's there in the other case also, both cases. B. Procastel, learned counsel, who said to be the lead counsel in the matter, is said to have some personal difficulty to conduct the case today. On a prayer made on his behalf, matter stands adjourned for 3 weeks.
lordship, date may be fixed. First week
Registry
of,
to, on the date to be fixed by the registry.
first week of September.
Next, registry will give a date.
May I please, your lordship. Lordship, I beg to mention item number 14. Lordship, my senior has some personal difficulty, therefore he not able to come to the your lordship. Kindly pass for the matter only for the day and fix any other detail.
14.
14, 1-4.
Who's your senior?
M.H. Ahmed.
What about the other side? Have you informed?
No, sir. I
If you
think
inform,
14.
okay. On the prayer made on behalf of Mr. M.H. Ahmed, learned counsel for the petitioner, and not opposed to by the other side. Matter stands passed over of the day.
May it please, Lordship. Lordship, I beg to mention for listing of matter. It was last posted on 27/8/25.
27/8.
Yes. 27/8.
We are not yet reached
Last-
27/8.
Last year. 25.
Oh, and last year,
Yes,
25.
yeah.
Okay, give a date.
Next week, Monday.
May it please, your lordship.
I beg to mention listing of in WBC for Friday, lordship. Matter related to recruitment process, lordship.
What, mention for what? Motion?
Motion is lordship.
What is the urgency?
Matter related to recruitment process, lordship. That's
Maybe matter, all matter, lot of matters are related to recruitment process. What is the special urgency in your case? When did you file it?
chip on 10.
That's just 2 days back. Yesterday only.
They fixed it on Friday, lordship.
Yes.
May it please your lordship. With the consent of the other side, I beg to mention item number 23. I'm for the respondent and I'm appearing on behalf of Mr. P. Sundi. Due to some personal difficulty, he has to go outside Gauhati.
P. Sundi.
P. Sundi.
Have you informed the other side?
Yes, lordship.
Therefore, adjournment has been made on behalf of Mr. P. Sundi, learned counsel for the respondent.
Respondent, sole respondent
There are 2 respondents.
for both the respondents.
Waiting for the respondents. What did I say? Respondents. On the ground that he's out of station. Stabili is also submitted that the consent of the other side is taken. In view of above, matter stands adjourned. Will it sit again after 3 weeks?
May it please your lordship.
Hmm.
I beg for listing of writ petition 1512 of 2024. Lordship, it was supposed to be listed on March of 2026, but it has not, never.
Okay, give
been
us a
listed. Wait, wait, let's.
May I please, your lordship? As per petitioner instruction, I have withdrawn the case, lordship.
Your good name?
AK Das, lordship.
Mr. A.K. Das, learned counsel for the petitioner, submit that he has instructions from the petitioner to withdraw the writ petition. Mr.
I'm standing for SC revenue lordship, respondent 1 and 2.
Mr. J. N. D. learned standing counsel revenue, in correspondent numbers 1 and 2.
Lordship.
For 3 and 4.
And Miss S. Borwa, learned
Permanent.
government advocate, appearing correspondent number 3 and 4 have no objection to the fair. Yes, but the petition shall dismiss as before.
Lordship, the interim order.
The order passed earlier shall stand vacated.
The lordship, the liberty will be given.
You never said liberty.
This matter may not yield much result of sending it to mediation may not yield much result in this matter.
Sorry?
Lordship, sending it to mediation may not yield much result in this matter because it's pertaining to their period of qualifying service.
What basis are you claiming qualifying service?
Lordship, Lordship, they were recruited by the select list of 1993. Lordship, the appointments were made not adhering to the merit list. We approached before this honorable court. Honorable court said that adhere to the merit list, appoint accordingly, and if any juniors have been appointed prior to us, they may be thrown out as per due process. Now, Lordship, what the authorities did was persons who were below us in the merit list were appointed in the year 95-96. We were appointed in the year 2001. For that purpose, Lordship, the qualifying service of 25 years we could not complete. Now, this honorable court in earlier around 2003-4 orders stated that you should adhere to the merit list in our case. But what they did was, without adhering to the merit list, my persons who were below me in the merit list, in the select list, were appointed ahead of us. Therefore, we have claimed that the date from which the persons who were below me in the merit list were appointed, from that date, my period should be counted towards qualifying service, and we be granted the full superannuation pension, Lordship.
Have you retired?
Lordship, yes.
All of you?
All of us.
Yes. You're there?
I'm for cooperation, my lord. There is on legs.
You're Mr.
A. Chakraborty, Lordship.
Okay, Mr. A. Chakraborty, learned counsel for the petitioner submits that considering the subject matter of the writ petition, the matter may not be sent for mediation. Of the learned counsel submits that after full stop. The aim of the petitioner is for grant of qualifying service so that they can get the benefit of their seniority. From the date before the juniors were appointed to the post of junior inspector of the auditor. Considering the same, let the matter be listed for. What about the pleadings? Not yet
Lordship,
completed.
affidavit has not been filed yet.
Be listed for admission after 3 weeks. Respondents to file their counter affidavit in the meantime.
Obliged, Lordship.
I'm paying for respondent 4 lots. Item 1 lot, I'm paying respondent number 4 lots.
Yes, where is your affidavit?
I mean, not. a
Why do you
necessary
appear, huh?
party- Not a necessary party lots.
You're not a necessary
Not
party.
necessary party. It's a formal party.
Then why do you not want your name to be there? in the order?
Lordship, our representation has been rejected based on a letter issued by respondent number 4.
I'm not saying anything. You file an affidavit.
Lordship.
Yes.
Obliged, Lordship.
May I please your lordship? May I please your lordship?
Yes.
My lordship has instructed Mr. R. H. Chaudhary, my lordship is appearing in this matter, my lord. I am appearing on behalf of him, my lordship. We are not opting for mediation, my lord.
Why? Why? Regarding recovery.
Yes, your lordship, because we have yet to file affidavit in this matter, but as per my instruction, he was wrongly promoted to the post of LDO, your lordship. And thereafter, during the pension, we have to recalculate his amount of pension, your lordship.
Okay, so it has to be thrashed out in by way of merit. Learned counsel for the parties submit that the matter may not be referred to mediation. If the matter relates to recovery of excess amount drawn. So according to the respondents, what did you just say? The excess payment was made.
Yes, your lordship, excess payment made by the department to the petitioner regarding pension. Pension also, he has made some excess payment, your lordship.
Why? Why?
Because during his pension period, it came to the notice of the authority that he was wrongfully promoted to LDA, your lordship.
Okay.
That is why.
Last line, what do you say? Excess payment was made on account of wrongful promotion. Next paragraph of above is the matter for in the admission column after 3 weeks. Respondents to file their counter affidavit in the meantime.
How will I say that?
Hello, please.
May I please your lordship? My lord, considering the subject matter of this case, my lord.
What is the subject matter?
My lord, the petitioner filed this writ petition with a prayer for re-evaluation of his OMR sheet, my lord, wherein he mistakenly, my lord, filled one wrong dot in the roll number column.
Yes.
Lord, just.
My lord, it cannot be decided by mediation. It can
Okay.
be by a judicial pronouncement is required, my lord.
Okay. It is submitted by the parties that the matter may not be referred for mediation. Because the matter pertains to claim of the petitioner that there was wrong evaluation of the OMR sheet. In view of above, is the matter for admission after 3 weeks. Respondents to file their counter.
A date may be
It's
fixed.
not wrong evaluation, it's no evaluation. It is not wrong evaluation, it is no evaluation.
evaluation.
Because of his rule number is wrong, incorrectly, my lord, wrongly put, my lord, that's why it is not evaluated. It is non-evaluation of the, my lord, Manchester.
OMR sheet.
OMR sheet,
Your case is non-evaluation.
not
Yes, ma'am.
evaluation.
Wrong, instead of wrong evaluation, you write no evaluation.
No,
No evaluation.
because he's not giving properly, but that
Correct rule number.
correct rule number is not put,
Okay, list again. On search of you.
my lord.
8 September.
Of like. My lord, in this case, as per earlier order, they are supposed to file affidavit, my lord. The petitioner was retired as a assistant secretary of the Assam State Marketing Board, my lord. And he was entitled for some aerial salaries, my lord, after fixation of his seniority. And his salary till
Your claim is for area salary.
area salary, my lord.
Can it be sent for mediation?
My lord, it's up to them whether they will.
File my reply, that can file my reply after that.
Reply in the sense? Affidavit
Affidavit,
opposition.
affidavit, I'm sorry, affidavit.
Affidavit opposition not filed, but before that, can it be sent for mediation?
Or the
But
some.
they have to take a stand, my lord, because I am also praying for pension.
regarding his monthly salary for May and June already released Lordship. And Lordship regarding his release of the payment area salary, Lordship, they have stated two case numbers in paragraph 3 that one civil rule 2006 or 1992 and one writ appeal number 91 of 1990. They have not annexed it. So this matters are required Lordship, to file an affidavit. Paragraph 3
This
they
was-
have stated.
This was relating to my initial appointment, my lord. I challenged
He
the
claim
selection.
from 1992. So these two orders is required, Lordship.
Which order?
In paragraph 3, Lordship, they have stated that one civil rule number 2006 of 1992. In paragraph 3, Lordship. Certification initially have not appointed in the and one writ appeal. 91 of 1993, they have not annexed in this petition, Lordship, though they have referred it. So that documents is required. Whether he is entitled for 1992 or not.
Yes.
My lord, in pursuance of this order, we were appointed, my lord, and that is at page 34, my lord.
But where is that order? You have not annexed it.
No, my lord, because it was in compliance of that order, we were appointed, my lord.
So you
Anyway, I
produce that
can
order.
produce that order.
Produce that order.
Yes, my lord.
So it cannot be sent for mediation. Or what?
My lord, if they agree, we can always,
Also, already we have released the salary to
salary-
and
salary they have released.
regarding Lordship, his area salary from 1992, which has been claimed, that the both the orders are required.
Our pay was refixed, my lord, but that area part we were not paid. We were paid on the original pay scale only.
All right, you all appear before the mediator along with the civil rule and writ appeal copy.
Yes, ma'am.
As agreed to by the parties that the matter be sent for mediation. The petitioner shall however produce a copy of the order passed in civil rule number 2006 of 1992.
And writ appeal number 19 of 1993.
And in writ appeal number 91 of 1993. In the mediation. For erosion of the parties. Oh, no, right, for necessary action. Yes.
I will finally reply in the meantime. I mean, affidavit. Because there's
You prepare an affidavit. You go to the mediation cell, so it'll not be possible to find.
So let them find an additional affidavit to bring this.
We'll file it. You will have, all of you will appear before the mediator and you see what we have to say.
My lord, if any date is fixed, my lord, for
They
me.
will fix a date because we don't know the latest.
Obliged.
Lordship, time being, the affidavit is not yet, we have called for with lordship permission.
Not come, or it's not fine. Okay, timing then.
Okay, obliged, lordship.
May I please, your Lordship?
Yes.
Lordship, yesterday we filed our affidavit, Lordship.
Which respondent?
Contemner, Lordship.
How many
Sole
contemners are there?
sole contemner.
Huh?
Sole contemner, Lordship.
Sole contemner. Your good name?
R. Dev, Lordship. On
R.
behalf of SS Roy.
R. Dev.
R. Dev.
Miss R. Dev. Before that, you write, none appears for the petitioner when the matter is called. So Miss R. Dev, learned counsel appears
On behalf of SS Roy.
on behalf of Mr. S.S. Roy, learned counsel for the sole respondent. Stop, she submits that an affidavit has been filed yesterday. Stop, it is however seen that the affidavit is not on record. Registry to verify and post and connect the same to the record. At least the matter is laid on 26/8.
Obliged.
Please, your lordship, service completed lordship as per Lozima last order lordship. But respondent affidavit has not been filed till date. So matter may be come for admission if
Service complete on whom?
service completed or
On-
Jila respond,
On which responded?
all respondent lordship.
Lawazima court's order is regarding respondent number 3.
3 yes lordship.
What about the others?
Others already completed.
Please write office note dated. No, cancel that. Lawazima court's order dated 31/7/2026 indicates that AD card has not returned back from the respondent number 3. But upon tracking the postal consignment, the notice appears to have been delivered to the addressee on 30/5/2026. So therefore, service upon respondent number 3 can be said to be complete. Stop in view of above. Notice is accepted to be complete on respondent number 3. Your good name?
M Das.
Ms. M. Das, learned counsel appears for the petitioner. None appears for the respondents. Although Mr. A.K. Ghosh, learned standing counsel. Which department?
Jila Parishad.
PNRD had appeared for respondent numbers 1, 2, 4, and 5. On 18/5/2026. Next para, forensic of justice, list the matter again after 3 weeks. Respondents to file their counter affidavit.
To date maybe.
Give a date,
Obliged lordship.
instead of 3 weeks, no? Like, that's the number.
Lordship,
Yes.
I am appearing for respondent number 1, Lordship. Today is 11th, Lordship. Yesterday, Lordship, evening, my office received a notice dated 10/8/2026, Lordship. In the notice, it is specifically mentioned you are hereby directed to attend this court at 10:30 on 11th day of August 2026 in person or through counsel. So immediately in the evening, she instructed me to appear before this honorable court today, Lordship. So I am appearing, Lordship. Like if Lordship comes to the direction, Lordship, alleging, willful violation of which this contempt proceeding has been initiated, Lordship.
Mr. Naik, this is for personal appearance.
Yes, today morning I also went through the, direction passed by this honorable court.
Notice may be something, but the order
Why
says.
is misleading, my lord?
I'm not
Why is
misleading.
misleading?
I'm only
He's
reading
saying
the
that
notice.
personal
I'm only reading the notice, Lordship. I'm only reading the notice dated 10/8/2026.
No. See, you have to read the order also.
Yes,
Notice
Lordship,
may say something
yesterday,
else.
yesterday evening, Lordship, only this, notice was communicated to me, Lordship. It was around 8 in the evening, Lord.
But respondent number 1 is aware about this order, isn't it?
Not aware, Lordship. That is what I am submitting, Lordship. It is notice dated 10/8/2026, only yesterday, Lordship. Our office received this notice on 10/8/2026. In the, in the evening, it was placed before her, Lordship. In the evening, around 7:38, Lordship, I was instructed by her, you kindly appear before the court. Today, I have received this notice. So that is what I am submitting, Lordship. And in the notice, Lordship, it is specifically mentioned in person or through counsel, Lordship.
No, don't repeat that again. We're not interested in that notice.
Yes.
See, the orders otherwise says that. It says. Court is inclined to direct personal appearance of respondent numbers 1 and 2. The date of personal appearance is fixed on 11/8/2026.
Definitely there is a gap.
It's clear, very clear, you see.
No, if Lordship direct, even now she can appear through, I mean, video conferencing.
No.
Only
A
difficulty is
personal
that.
appearance, it doesn't mean VC appearance.
No.
Don't go that way, you see.
Like, in fact,
See,
difficulty.
we have no, we don't take any pleasure in asking somebody to come and appear in person, but there's an order already here.
Lordship.
So, number one, allegation is non-compliance of the court's order. Number two is non-appearance of the person despite receipt of notice.
Lordship, difficulty was that on her behalf, Lordship, Wakalatnama was filed in the month of May itself, Lordship. One advocate was engaged, but unfortunately on the last date, he
She should
preferred
be
not
here
to
to
appear.
explain,
Yes,
not
Yeah.
you.
yes, today morning I went
When
to,
can she come? Otherwise, we issuing a bailable, non-bailable or mailable warrant of arrest.
today, Lordship. Today. Otherwise, Lordship, I'm praying for some time, Lordship. In the meantime, Lordship, we have received the proposal from the Silchar Municipal Board on 7th, Lordship, 7th
Let
of
us
this
appear
month
at 2.
at 2,
At
Lordship.
2.
If
Otherwise,
Lordship,
consequential orders will come.
may I submit, Lordship? Very recently, she joined her service after
Maybe.
child care leave, Lordship. If Lordship permits on video conferencing, Lordship. A lady, Lordship.
Order is already there.
No, she is,
I don't intend to
that
modify
medical
this.
issue is also there, Lordship.
Sorry?
Very recently, she returned to her job, Lordship, after child care leave, Lordship. A lady, Lordship.
Mr. Counsel, please inform. If she doesn't come, then it's up to her. We'll have to pass necessary.
At 2 level.
At 2.
Lordship, I am appearing for the contempt number 2.
Yes. Where is
Here
your?
in this case, the difficulty is that this contempt number 2 is presently at Choraido, posted at Choraido. Only yesterday she has informed me, and probably she has not received any communication from the other respondents. She has been communicated over phone. She has not
We'll
received any.
consider this at 2. Okay.
Lordship, from
You be here.
Choraido, Lordship, it will be very difficult for her to come. Lordship.
We'll consider your submission at 2. Please take.
Otherwise, she is not presently holding the post of managing director.
Maybe.
She is not the managing director.
Lordship will consider this aspect at 2, Lordship. Why an order dated 7 was communicated only on 10th?
Exactly.
Only on 10th.
That was not communicated. On
If I go through the notice, Lordship, it is also misleading, quite misleading.
Mr. Counsel, at 2, let the person be here.
That she will appear,
We'll
Lordship,
see.
as your Lordship has directed, she will appear. But this notice is quite misleading, Lordship. It should not
Maybe,
have
we
been.
don't know. We'll see at 2.
And more to that, Lordship, there is no deliberate disobedience because on 4/8/2026, the Silchar Municipal Corporation has only sent the proposal to the government. Lordship. Very recently, it has been sent. Lordship.
Next item. I said at 2.
Yes.
Why do you keep on submitting like that?
May I please, your lordship, this case is filed in the year 2024, lordship. Till date, no affidavit, no review, no appeal has been filed, lordship. And moreover, lordship, there is an order of 20, lordship, kindly peruse 25/5/2026, lordship, order, lordship.
Have you received a copy of the affidavit?
Yes, lordship. That is on record, lordship.
You've gone through it?
Yes, lordship.
Lordship, in this matter, we have filed our affidavit in opposition, my lord, wherein we have, my lord,
Just a minute, just a minute.
And then order, lordship, 25/6/2026, maybe.
Let us see the order,
Yes.
which is not, alleged to be not complied with.
para 23, is the relevant portion.
Page number.
Page number, Lordship, will find, page 20, Lordship.
20. Paragraph 23.
And the relevant portion, yes. May I read, Lordship?
Yes.
Lordship, I am reading from paragraph 22, Lordship. Before concluding, it would be pertinent to note herein that it is a matter of public record that in the state of Assam, the original works department was the Public Works Department, which continued to deal with all types of work required in the state of Assam. With the passage of time and with the demand of various kind of working rising in the state, the Public Works Department was bifurcated from time to time so as to give work several other departments, including flood control department, so and so, so and so. Therefore, since the Assam Subordinate Secretariat Service Rules 1963 clearly includes the PWD Secretariat within its fold, it cannot be said that the Water Resources Department should be treated to be outside the purview of the rules. In any event, since the petitioner has continuously served in the Secretariat branch of the state of Assam, his services must be treated to be one under the control of the Secretariat Administration Department, now renamed as ZAD. Therefore, respondents cannot refuse to consider the petitioner's case for promotion by taking the plea that his initial appointment was not made by SA department. For the reasons stated herein above, the writ petition succeeds and is allowed accordingly. The respondents number 1 and 4 are directed to consider case of the writ petitioner for promotion of the post of JA by extending similar consideration as has been done in case of Gajendra Kumar Rai in the light of the judgment and order dated 27/11/14 and 29/8/18 passed by this court. The exercise be completed within a period of 4 weeks from the date of receipt of certified copy of this order. And accordingly, I have submitted my certified copy of the order before the respondent authorities, Lordship. But Lordship, surprisingly, Lordship, during the pendency of the case, Lordship, on Lordship, uh, 4/6/2026, page 37, Lordship.
Annexure A1.
Page?
Page 37, Annexure A1. A1.
Yeah, affidavit filed by me, man.
Yes.
May I read, Lordship? Peruse the order of the Honorable Court so and so Sri Dinesh Kumar Singh versus State of Assam so and so. Peruse the letter dated so and so. The main content of the case is that Sri Dinesh Kumar Singh initiated a court case in the Honorable High Court Vice so and so due to reason of not being promoted from the post of grade 4 to junior admin assistant. Peruse the relevant records. From the records, it is found that the petitioner was initially appointed by the Flood Control Department and was posted in grade 4 in the Water Resource Department by Water Resource Department. Records further show that the promotion for the post of junior admin assistant, a grade 4 employee, has to be proficient in computer application so and so, subordinate secretary rules 1963. As per available records, the petitioner was allowed to appear in the computer proficiency test held on 5/10/24, being the last chance to get promotion for employees of the other department, similarly situated persons. Records further show that the petitioner did not qualify in the computer proficiency test held on 5/10/24, and as per the Assam Secretary Service rules, he is not eligible for promotion. In view of the above, after the consideration, the petitioner could not be promoted to the post of JA, thus the matter is disposed of. Lordship, in the order, Lordship, after perusing all records and affidavit in opposition, the Honorable Court clearly directed to promote the petitioner like one similarly situated employee, namely Gajendra Kumar Roy, who has also got promoted, Lordship, in terms of this court's order, Lordship. And accordingly, this Honorable Court in the judgment and order clearly directed to consider his case in terms of that order also, Lordship. And in case of that employee, Lordship, Gajendra Kumar Roy, kindly peruse the order dated, Lordship, 25/6/2026 of this Honorable Court, Lordship. Here in this case, Lordship, the said Gajendra Kumar Roy's no computer test was held by the authority, Lordship. But Lordship, in this case, Lordship, they have initiated a process of computer test, Lordship, and accordingly petitioner was appeared, Lordship. But there was no such direction to appear the petitioner in the computer proficiency test.
Lordship,
In the judgment and order clearly directed, promote the petitioner like Gajendra Kumar Roy. And Gajendra Kumar Roy, no computer proficiency test was held, Lordship. Kindly peruse dated order dated 25/6/2026 in this contempt case, my lord.
Lordship, if I can submit.
Mr. Matkan, why do you interrupt? Or you want to submit first?
No, no,
This is not the way, you see. Somebody is submitting in.
My lord.
Kindly peruse 25/6/2026 order. This honorable court also wanted to know whether that Gajendra Kumar Roy's computer test was held or not, Lordship.
No.
But Lordship, they have failed to produce that evidence that in respect of Gajendra Kumar Roy, computer proficiency test was held, Lordship. And prior to that order, Lordship, I have already applied for RTI, Lordship, whether in case of Gajendra Kumar Roy, computer proficiency test was held or not, because there was a direction of this court.
And what was the reply?
Reply, Lordship, yes. I have brought by you an additional affidavit, Lordship.
You tell me whether it was held or
Yes.
not, that's all.
No.
Okay.
Their reply is, Lordship.
Let us revert back to the judgment and order.
Yes. Lordship, kindly first peruse the reply, Lordship, page 44.
Page 44.
44 of the RTI application. Lordship, reply, Lordship.
Problem is that there is no page 44.
Running page, Lordship.
Running page or not running page, there is no page 44.
Lordship, today I have brought that on record, Lordship, additional affidavit.
You say that additional affidavit.
Yes. Lordship, my question was, kindly provide a copy of the order relating to the computer proficiency test of Gajendra Kumar Roy, peon conducted before his promotion as per WBC number so state of Assam. And their reply is page 44, Lordship, point number 1, 2, 3, and 4. The information documents sought under these points are not available in this department, Lordship. And that order was, Gajendra Kumar Roy order was in the year of 2019 only, Lordship. In that case, Gajendra Kumar Roy's no computer proficiency test was held, and accordingly he was promoted, Lordship, because there is an order of personal appearance, Lordship. According to the, so in terms of that order, Lordship, they promoted that person. And in this case also, in the judgment and order clearly stated.
Where is your query?
Yes, Lordship.
You have just annexed the reply.
Query that not relaxed, but I have, Lordship. But answer is I submitted.
Just read the query. What have you written?
Query was, Lordship, kindly provide a copy of the office order relating to the computer proficiency test of Gajendra Kumar Roy peon conducted before his promotion as per WBC number 564/2015 and contempt case number 507/2018, Sri Gajendra Kumar Roy versus State of Assam and others.
Point number?
Lordship.
Question number?
Question number 1.
1. So 1, 2, and 1, 2, 3, and
Yes,
4 are
yes,
taken
directly,
together.
Lordship, they have given not available. Other questions were also some similar situated person who also got promoted, Lordship, without any computer proficiency test. And here in this case, Lordship, they are, Lordship, they have conducted a computer proficiency test, Lordship, which is without any jurisdiction, Lordship. And this is also another contempt, Lordship.
This is the post of JA.
Junior Administrative Assistant, Lordship.
Junior?
Administrative Assistant.
Where?
In the Assam Secretariat, Lordship.
Secretariat?
Yes, Lordship. And this was clearly directed by the order dated 25/5/6/26. You bring instruction whether that test was held in case of Gajendra Kumar Roy or not, Lordship, but they failed to do so, Lordship.
What was the case of Gajendra Kumar?
Gajendra Kumar Roy, Lordship.
He was also a grade 4,
Grade 4, same post, Lordship.
same post.
Yes, Lordship.
He's senior or junior to you?
Lordship, he is Lordship, junior to me, Lordship.
Junior to you. He was given the benefit of promotion.
Promotion, Lordship, with retrospective effect from the data promotion is next junior also, Lordship. He has given all benefit, Lordship.
With effect, with the
Retrospective
from-
effect, Lordship.
From?
From which that he was required to be promoted, Lordship.
Required to be promoted.
Because some of our junior already got promoted, Lordship, before promotion of the Gajendra Kumar Roy, Lordship.
What
And
is the-
accordingly,
What
direction
is the criteria for promotion to JAA?
from grade 4 to grade 3, Lordship.
What is the criteria?
Criteria, Lordship.
Seniority?
Seniority also one of reason, one of them.
And what else?
Yes, Lordship. That is also one of reason.
See, from a grade 4 post, you're going to a clerical post of junior administrative assistant. What is so surprising about computer tests?
That
Is it not a basic requirement?
Yes, Lordship. Subsequently, they have brought one notification, Lordship, computer test. is
Computer, you don't have to be a programmer or something like that, but at least computer proficiency test will be required. A person who does not know how to
Yes,
operate
Lordship, from
computer.
a peon, how can Lordship? But subsequently,
why-
it is amended, Lordship.
Huh?
But subsequently, it is amended to computer proficiency test, Lordship. But before passing of that amendment, Lordship, this order was passed, Lordship.
Passing of the amendment, when was that?
Lordship, now they have amended one notification, they have brought by one notification, Lordship, computer proficiency test. is
When?
Mandatory, Lordship.
When?
Yes, Lordship. Lordship, it was 15 March 2017, Lordship.
17.
Yes,
So this judgment is of the year 2023.
Lordship, 23. But Lordship, this was Lordship, but he was his promotion was due prior to 2017, Lordship. That is why Honorable Court has directed this order, Lordship. Prior to coming into effect of that notification.
This judgment and order of 2014 and 2018
Yes,
pertains to Gajendra Kumar.
yes, Lordship.
What did it say?
Lordship, kindly peruse paragraph 15, Lordship. Page 18 of contempt petition. In the order, it is reflected. May I read, Lordship?
It's okay,
As-
just a minute, I'm reading it.
Yes. Without insisting on the enhanced educational qualification.
Then the other judgment, 29/8/18.
Lordship, that was order of contempt, I think, Lordship, 29. 8. Yes, Gajendra Roy's order, Lordship. Yes, that order, paragraph 6, Lordship will find clear order.
It speaks about the rules of 1963.
Yes, Lordship.
And 1999.
99. Subsequently, it was amended, Lordship. That Gajendra Roy's order, Lordship will find in paragraph 6 of the judgment, Lordship.
This
Contempt case, Lordship.
abstract of paragraph
Yes,
13.
yes, Lordship.
Paragraph 13.
Yes, paragraph 13, Lordship, yes. Because their promotion was due, Lordship, prior to 2012, Lordship, before coming into force of the notifications.
Nineteen sixty rules.
Yes, Lordship.
When was it amended?
Lordship,
Introducing the
yeah, it was amended in the year 2012 also, Lordship. But their promotion was due, Lordship, prior to coming into force of that notification also, Lordship. That is why Rule 2017 subsequent notification is also not affecting this petitioner's case, Lordship. In the order, paragraph 13, it is clearly stated, Lordship. That is why, Lordship, that is also not applicable.
yes.
And Lordship, thereafter, Lordship, they have come with an affidavit that because his petitioner's case has been rejected because petitioners failed to failed in the computer proxy entities. There was no such direction as
Okay,
of
okay.
to
I've
help
understood.
computer
Mr.
proxy.
Kukan, you tell me now.
Yes, that is also another contempt, Lordship.
Chief, first of all, my lord, the additional affidavit which has been filed today, my lord, I mean, which has been filed, my lord, I have received it today, my lord. I was indisposed for the last week, my lord. However, my lord, I would like to first come to, my lord, the judgment, my lord, which we have to comply with. That is WPC 3797 of 2020, which is, my lord, which is dated 15/6/23. This is the judgment which was delivered on 15/6/23.
Mr. Pukan, you come straight to page 15,
Yes, Your Lordship, para 23.
paragraph 6.
My lord, my
Paragraph 6.
Lordship,
Below paragraph 6, you will find the abstract of paragraph number 13,
my lord.
which was the order passed in that case. The case of, what is his name? Gajendra Kumar.
My lord.
Please read that. Page 15.
In view of the stand taken by the state respondents that the promotion of the petitioner from grade 4 to the post of JA will have to be done by the Secretariat, Administration Department, that the 1963 rules would be applicable for the considering the promotion of the petitioner. So and so is directed to consider promotion of the petitioner so and so, so and so.
Yeah, don't say so and so. Please read carefully.
My lord.
It's important.
Department may not applicable. I've gone through this one. Will be applicable for considering the promotion of the petitioner. The Secretary is directed to consider the promotion of the petitioner from grade 4 to grade 3 JA post as per the 1963 rules and 1999 rules, as the vacancies occurred before 2012 rules came into force. The same should be done within a period of 2 months from the date of receipt of a certified copy of this order. In the event it is found that the juniors of the petitioner have already been promoted, the state respondent shall promote the petitioner with effect from the date of his juniors have been promoted. No, this is.
Please pause there for a moment.
Gotcha.
Question relates to promotion from the grade 4 post to the JA post, correct?
Yes, sir.
And the recruitment rules is regarding it's 1963
I know.
and 1999 rules. Now, here's a case when the vacancy occurred prior to the amendment made in 2012
I know.
as regards to the rules of 1963.
I know.
Now, direction has been given to consider him as it existed then because of the vacancy which occurred prior to the amendment in 2012. And secondly, if any of the juniors have been promoted, he should be given that benefit with effect from the date the junior was given promotion. That was in respect of Gajendra
Ray.
Ray.
I know.
So coming back to our case, this court had a categorical finding and concluded at page 20, at paragraph 23,
Paragraph 23.
that extending similar considerations in case of the petitioner. That is what has been said. Time frame has been given. Now you come up with an order on 4/6/26 saying that he was asked to sit for the computer proficiency test held on 5/10/2024 as per the service rules of 1963 as amended. But he failed. Matter ends there.
Lordship,
So is this compliance of the court's direction?
Lordship, if Lordship allows me to kindly read paragraph 23 once again.
23.
If I can, if I'm allowed to read it.
23 of the
my lord, main order. The order which we have to comply with.
Yes,
The last part.
Read.
For the reasons stated here and above, the writ petition succeeds and is accordingly allowed. And my lord, this part is crucial. The respondents numbers 1 and 4 are directed to consider, my lord. It is not, my lord. It is directed to consider the case, my lord, not, my lord, to give appointment, my lord. The case is here, my lord, that the court has directed them. Court has not given a direct order that, my lord, give him appointment. The court has given that. The respond 1
Don't
and
be
4.
hyper technical, Mr. Counsel.
My lord, I have to be, my lord.
See,
My lord,
you have to be, you will be.
my lord, I have
But
to point out.
this
my lord.
court is also not oblivious
I'm
of
just
this.
pointing out. I'm just pointing out.
See, court is not oblivious of the direction which court can pass.
My lord, no.
Court will never say appoint him now.
My lord. So, my lord,
By 13th of August 2026, appoint him.
my
Court
lord,
will never say that.
court, my lord,
Court will say that this is the thing, he has made out a case. Now consider his case for promotion.
my lord.
That is your duty to do, consider and promote him.
So we considered him. my lord.
And the parameters which is given to you for consideration is as per the benefits given to this Gajendra Ray,
My lord.
Kumar Ray.
I'll come to that.
And you have deferred.
My lord, I'll just come to that.
You have deferred, saying that now we have an amendment. We have the computer proficiency test in place. So he has to go to that
My lord,
computer.
what has happened
And
is,
person who's working in grade 4 post since long time back, for him to go to the computer thing, you know very well how expert he will be. He has failed.
I'll just complete the whole. I'll just give the whole chronology, my lord, because if I have to, because my lord, I have to say the whole what has happened, my lord, because otherwise I wouldn't be able to explain, my lord.
Yes.
My lord, after the direction has been given to 1 and 4, my lord, to consider, my lord. So accordingly, the department in compliance of this order, my lord, has considered, my lord, If a lordship comes to my lord, first comes to the page 37, that is annexure A1. The order which we have passed, which according to us is in compliance with this order, because we have been asked to consider this case. So we considered this case accordingly, my lord. Peruse the order dated so and so. Main content, my lord, of the case is that Dinesh Singh initiated a court case in so and so and so. Peruse the relevant records. From records, it is found that the petitioner was initially appointed in so and was posted as grade 4 in the water resource department by the water resources department. Records further show that for promotion to the post of junior administrative assistant, my lord, a grade 4 employee has to be proficient in computer application as per Rule 8.3 of the Assam Secretariat Services Rules 1963 as amended up to
As
date.
amended.
As amended, my lord. Well, kindly see this, my lord. As per available records, the petitioner was allowed to appear in the computer. My lord, one thing we'll now note here is that he appeared in the computer proficiency. He participated. It's not that he should have avoided. He should have directly come for contempt. I'm just giving an example. my lord. He participated in the proficiency
Grade
test.
4 employee,
My
does
lord,
he have
I-
a choice?
How can I can reject
My lord,
lordship
I think-
official
let
order?
me
Mr.
complete.
Talukdar, I've
So-
understood your case, okay, don't provoke.
As per available records, my lord, he participated in the computer proficiency test, my lord, held on 5/10/24. And my lord, being the last chance to get promotion for employees of other departments, similarly situated persons, records further show that the petitioner did not qualify in the computer proficiency test held on so and so. And as per the Assam Secretariat rules, my lord, this is a rule, my lord, which is backed by it's Article 309 rule, my lord. And my lord will now come to the main rule, my lord. I will show the main rule once before, because I've annexed it in the affidavit. Lordship directly comes to page 30, page 40, man. Page 40 of this particular affidavit which I filed. It's an Assam Gazette, my lord. Page 39 is Assam Gazette notification, my lord, 15 March 2017, my lord. This is my lord, this thing, my lord, backed by Article 309 of the Constitution of India. So, my lord, amendment of Rule 18, 4, my lord. In the principal rules in Rule 18 in Sub-Rule 3, in Clause B, for the existing second paragraph, the following shall be substituted, namely, the candidate for the post of junior administrative assistant must possess knowledge of computer as specified below. He must have good working knowledge of the office productivity software tools, independent of any operating system that is so and so, such as so and so, a word processor, spreadsheet, presentation graphics, concept of database, internet, email. He must possess minimum 6 months diploma certificate in computer proficiency from a recognized institute. He must prove his proficiency in computer through a practical test. So he appeared for the practical test, my lord, in 3, and he failed. And my lord, what has happened is now whoever becomes a JA, now all the work is, now everything is digitized. So the problem is, my lord, they all go through this one. And the Gajendra case was way back, my lord. If your lordship sees the Gajendra case, it was way back. And that is why at that point, my lord, may have been, my lord, he was considered.
Is that explanation
But
available to you,
in this case, my lord, he participated,
Mukherjee?
my lord, and there's a specific rule, my lord, which we have followed.
Rightly or wrongly or whatever it may be, you have not preferred any appeal. Have you preferred any appeal?
We have passed a compliance order.
Have you preferred any review?
My lord, we have not, because we have
Then
passed.
why do you justify your action like that?
My lord, that is the thing I just.
This court, as a court considering contempt petition, has no business in going to the merits of the case. Correct?
He can challenge this order.
You say that he can challenge.
He can challenge.
Prior to he can challenge, that question is whether you have complied or not. What about that aspect?
Rightly or wrongly, we have complied, my lord, because as per the thing, my lord, we were asked to consider. It was not that, my lord, give him the job as the junior. If you lordship again sees, my lord, paragraph 23. It is paragraph 23 categorically states, my lord, that for the reasons stated here and above, the writ petition succeeded as accordingly allowed. The respond number 1 and 4 are directed to consider the case, my lord. It's not that promote him immediately to the post of JA. It is to consider. So we have considered.
How you have to consider?
And we have.
How you have to consider? You tell me.
Consider the case.
Are you to consider independent of Gajendra Kumar's race case?
My lord, we have taken that into consideration. Plus, we have taken the rule.
Where have you taken into consideration?
My lord, we have called him in.
If you have taken that into consideration, this would not have been the result.
My lord, we have called him in also.
Mr. Khan, I don't think there's something wrong here.
And my lord,
you have to explain.
So we
I'm giving you. I'll give you some time to explain.
Plus the affidavit, I'll get the instructions, my lord. He has filed it. I have received today, my lord.
Please write.
Also,
Art Mr. R.K. Talukdar, learned counsel for the petitioner, who submits that the direction of this court, white judgment and order dated 15/6/2023, passed in WPC number 3797 of 2020 has not been complied with. Stop. The learned counsel submits that which respondent has filed the affidavit?
My lord, one number,
You are appearing for which respondent?
one number one.
He submits that the respondent number 1 has filed additional affidavit
Yes, respondent number one.
on 26/2026, annexing an order dated 4/6/2026, passed by the Secretary to the Government of Assam, General Administration Department, whereby the case of the petitioner for promotion was rejected on the ground that he did not qualify the computer proficiency test that was held on 5/10/2024. Stop. Next para, the case of the petitioner in the writ petition, in short, was to consider him for promotion from the grade 4 post that he occupies to the post of junior administrative assistant, bracket JAA. So this court, while considering the writ petition, by taking into account the direction earlier made in WPC number 564 of 2015, bracket Gajendra Kumar Ray versus State of Assam and others, close bracket, who was similarly situated like that of the petitioner, and in fact junior to him in the grade 4 post, directed the respondent authorities to consider the case of the present petitioner in terms of the consideration made for Gajendra Kumar Ray. Stop. While disposing of the writ petition, paragraph number 13 of the judgment rendered in the case of Gajendra Kumar Ray was abstracted. Stop. The same is also abstracted here under page 15 and 16, A to A. Next para, the learned counsel for the petitioner submits that since the vacancy in the JAA post occurred prior to coming to force of the 2012 rules, and before the amendment of the Assam Secretariat, grade 4, and Record Suppliers Service Rules 1963. The case of Sri Gajendra Kumar Ray was considered without putting him without, without, without asking him to go through computer proficiency test. Stop. Since computer proficiency test was introduced only at a later stage in the year 2017, the present petitioner would not have been asked to undergo such tests. Stop. Therefore, the respondents have clearly violated court's direction. In not considering the petitioner, similar to the consideration given to Gajendra Kumar Ray, and secondly, by asking him to undergo the computer proficiency test. So next para, Mr. A. Fukan, learned counsel for respondent number 1. On the other hand, submits that the court's direction was to consider the case of the petitioner for promotion and such consideration has accordingly been done by the respondent. Stop. Secondly, the petitioner was asked to petitioner did not qualify in the computer proficiency test, which otherwise is compulsory for all junior administrative assistant working in the secretariat. Stop. Therefore, the respondents have only complied with the court's direction. Next para, it is however seen that the court's direction was to consider his case similar to the consideration given to Sri Gajendra Kumar Ray. Stop. A query was raised by this court on earlier occasion as to whether Sri Gajendra Kumar Ray was required to sit for the computer proficiency test or not, but no such instruction has been furnished to the court. Stop. The petitioner, on the other hand, has sought for information in that regard through RTI. Stop. The reply given against such query is that no such records are available. Stop. Under this circumstance, the respondents How many respondents are here?
Lordship. Respondents, Lordship. 4, Lordship.
I am for one. The main respondent.
One is what?
One is Commissioner and Secretary, Lordship, CAD.
The respondents, comma, more particularly respondent number 1. We'll have to clarify as to why computer proficiency test was held for the petitioner. Having regard to the specific direction given by this court to consider his case. According to the consideration given to Sri Gajendra Kumar Ray. It is also not in dispute that there is no appeal filed against the judgment and order dated 15/6/2023 in WPC number 3797 of 2020. Now, the respondent number 1 shall therefore file an affidavit clarifying the position as directed herein above within period of
3 weeks,
what, 3 weeks?
2 weeks, man.
2 weeks. List the matter again on 28 August.
Lordship may keep it at part heard, Lordship.
Twice?
Lordship.
Right.
Next.
May I please have a floor? Sir, this matter pertains to termination of the petitioner when she was at her advanced stage of pregnancy. The petitioner was after a due selection process.
Termination of service.
Yes, termination of.
Not termination of pregnancy.
Actually, she was appointed as a contractual worker or as office assistant after a due selection process. And initially, the annexure B at page 23 dated 12/8/2014. Initially, she was appointed for a period of 3 months at a consolidated pay. And subsequently, our period of service was extended from time to time. She was appointed in Institute of Advanced Study in Science and Technology.
Okay, who all are here in this case? Respondent?
Yes.
You are for the
I am for the resolution number 2, 3, 4, and 5.
2, 3, 4, and 5.
My lord, to submit one submission, my lord. In the affidavit in reply, my lord, the petitioner has made one allegation that some other persons of the institute has been regularized. But in that position, my lord, I have got the instruction that nobody, no person whose name was mentioned in the reply affidavit, my lord, that is not a regularization, but that is a complete different advertisement after due process, my lord. That is where I have got the instruction. If I am allowed to file an affidavit regarding that record, my lord, substantiating that that allegation that.
Yes,
that
my lord,
person-
because my contention is that persons who were selected and appointed like me, subsequently they were regularized in service.
Paragraph number of your.
That we have stated in our affidavit in reply.
Paragraph number
35, my lord, page number 116.
35. That interim order that will fill one Timothy Pinky Taye, who was selected and appointed by the same selection process and in the same manner as that has been regularized in her about 2 years back. We have nothing against her, but persons who were similarly selected and appointed were regularized in their service.
What post is this?
This is office assistant, madam.
Office assistant.
Office assistant.
Under which establishment?
So ISST, Institute of Advanced Studies. in
Institute
Science
of
and Technology.
Advanced Study
Under
in Science and Technology.
Department of Science and Technology, Madam, Union of India.
Any role by the respondent number 1?
Not, not directly, my lord, but since the
Have they filed any affidavit?
yes, my lord, I have filed.
Not you.
Respondent number 1.
Respondent number 1.
Prepared for respondent number 1. So they are the independent and authority decisions is taken by them only, not. So
So-
even if India is a party, they are the.
You have not filed affidavit.
No.
You will not be filing affidavit. Please write, parties are represented by the respective councils. Ms.
B. Sharma.
B. Sharma, learned CGC, appearing for respondent number 1, submits that she will not be filing counter affidavit since the matter is mainly between the petitioner and the other respondents. Stop. Mr.
D. Gogoi, my lord.
D. Gogoi, learned counsel, appearing for respondent numbers 2 to 5, submits that in view of the specific averment made in paragraph number 35 of the reply affidavit by the petitioner, he has received some instructions and he would like to file the same by way of an affidavit to respond to the same. Stop. Considering the fact that this matter is of the year 2018,
2 weeks time.
2 weeks' time is
Yes.
granted for the said purpose. List the matter again on 27/8.
All right.
Affidavit, in the additional counter affidavit be filed or not before the next date.
Bless.
Right, please, Lordship. In this case, respondents are supposed to produce record today. So, punishment of recovery was imposed in a disciplinary proceedings. Our ground is that inquiry is vitiated for violation of rules. And inquiry officer traveled beyond the record. There is no quantification of loss also, the inquiry officer.
They're paying for the other side.
Forest department also.
Forest.
Yes, forest department.
Do they have a council, forest?
Yes, the D. Gogoi was appearing on the evidence. So,
And what is the subject matter?
we are agreed with the punishment of recovery imposed upon him. The ground is that inquiry was vitiated for violation of rules. Rules of Assam Service Discipline Appeal Rules 1964, Rules 9(6), 9 sub rule 6, which says that oral evidence has to be recorded, opportunity of cross-examination has to be given. These are not given. Only statement from witness were in witnesses handwriting in the handwriting of witnesses statements were taken. Not it was no oral evidence was given, and opportunity of cross-examination was also not given.
Recovery.
Yes, recovery loss, and there is no quantification of loss.
Recovery of what? Excess payment?
No, it is a punishment. Recovery, they said there is a loss of the government due to fell of trees during I was a range officer. Fell of trees, there is a initially charge was for 19,70,000. And without quantification, that has been penalty was imposed. In appeal, it was reduced to 15,76,000.
Okay, you've gone through appeal also.
Yes.
Now record was required
Yes, it's on last
to
day.
see whether opportunity was given to you or not.
Yes, yes. We have annexed, but record was
They said that on last occasion that they have the soft copy, but it was a voluminous, so they have been directed to produce the records.
What do we do?
He was there, he was there.
Pass it over for the timing. We also inform. 7.
May I please, your Lordship. Lordship, 5/6/2026, current government advocate prayed for time, Lordship, to take instruction regarding the matter, Lordship. Otherwise, the matter is regarding payment of compassionate gratuity or pension, compassionate pension as per Rule 24 of the some service pension rules, Lordship, 1969.
Compassionate pension.
Lordship, gratuity pension, whatever my lord orders. There is a scope for scope under section Rule 24, Lordship.
What is the requirement to avail for 24?
Lordship, 24 is Lordship regarding the persons who were dismissed or terminated for the purpose of misconduct in the service, Lordship. And petitioner falls under
Compulsory retirement.
no, Lordship, falls under the category of dismissal from service for misconduct or moral turpitude, whatever, Lordship, but petitioner is falls under that category. Petitioner was initially dismissed from service, Lordship, for misconduct. One criminal case was there. In the meantime, he was convicted. He served his sentence, Lordship. Thereafter, he approached this honorable court for some violation of Rule 9 initially, Lordship. He was not properly given the chance to defend his case, Lordship. A single judge dismissed that case. Thereafter, he approached division bench. Division bench remanded the matter, Lordship. Again, it was again rejected. So he approached this honorable court again. This honorable court the single judge dismissed that matter, and in division bench, Lordship, Honorable Chief Justice and another bench, Lordship, said that in that appeal, Lordship, petitioner prayed for compassionate gratuity or compassionate pension, Lordship, as per Rule 24 of 1969 rules. Then Honorable Chief Justice and the bench asked the petitioners to approach the appropriate forum, Lordship. Therefore, this appropriate forum in through petition, Lordship. So because that prayer was not there initially.
So in all, how many writ petitions? This is the third.
This one, the third, Lord.
Third. So twice he went to division bench. Twice.
Yes, twice. Yes, twice. Lordship.
And this third is for
Lordship, there is an order of this honorable court, page 92, last page, last 2 pages of my writ petition, Lordship. At this stage, petitioner crossed the age of retirement, Lordship. He has nothing. Nothing has been paid to him. Before the incident, he served for 13 years, Lordship. But for that unfortunate incident, Lordship, he was dismissed. At this stage, he's praying for this compassionate gratuity, Lordship, for survival. Because he is now 60 plus 63, 64 like this, Lord.
compassionate gratuity. You have been dismissed from service.
Yes, it was long back, Lordship.
Dismissed.
I served my sentence also, Lordship.
You're dismissed from service and you are seeking for compassionate allowance.
Rule is there, Lordship. There is a scope. That's why, Lordship, before this honorable court, at this stage, some mercies, if can be granted to him for survival, Lordship.
I'll come back in 5 minutes.
Lordship.
Meanwhile, you take out that rule 25 of pension rules. I know.
Lordship, may kindly peruse Rule 24. I'm not praying for any pension, Lord. Lordship.
No,
From the records, Lordship, it's reflected that prior to incident, he served for 13 years, Lordship. He served for 13 years in the department, Lordship. Thereafter, the unfortunate incident happened. And for that,
you were convicted under what provision?
376 IPC, Lordship.
376.
34 was also there. Another person was also there. And for that, I served 5 years of RI for 5 years, Lordship. Sentence I have served already. From department, I have got nothing, Lordship. They have given nothing to me. At this stage, I'm just praying for something so that I can survive in rest of my life, Lordship.
You were working as?
A lens Nayak,
That's like where? Police?
police,
Assam police?
Assam police.
Now, this also says that this consideration can be given
On special occasion.
when they are deserving of special consideration.
Consideration, Lordship.
What is that special consideration to be given?
Lordship, my humble submission before your Lordship is that prior to this incident, he has served 13 years, which is quite a period, Lordship. Thereafter, he served his entire sentence, Lordship. That was my submission before the learned division bench also, Lordship. That's why my honorable division bench has allowed me to approach the appropriate forum, Lordship, for agitating this.
Perhaps the appropriate forum will be the government. They know you. We don't know you.
Lordship, may kindly see the order of this honorable court. Page number 92 and 93, Lordship.
Whether it's appropriate to be given to you or not, they'll be in a better position to know you.
To government, he went to the office, Lordship, but they are not entertaining him after so long period, Lordship.
Page?
92 and 93, Lordship. Since there wasn't any prayer for compassionate pension or gratuity,
What did you challenge in that writ appeal?
a writ appeal order of the single bench, Lordship, where my appeal was rejected, Lordship.
Appeal for reinstatement. Appeal for
Reinstatement after remanding back, Lordship, they again rejected my prayer, Lordship. And that was that I challenged before the learned single judge. Learned single judge dismissed that case, Lordship.
you filed the writ petition after you were discharged, or you had served the sentence.
Writ petition initially from after dismissal of my service, Lordship.
Challenging what?
Challenging my dismissal order.
Dismissal.
Order.
Then the second writ petition?
Second writ petition, it was remanded back by the division bench because there was some violation of Rule 9 of the Discipline Appeal Rules, Lordship. On remand, Lordship, they again rejected my claim. That order I have challenged in next writ petition. That was dismissed by learned single judge. On appeal, when I prayed for compassionate gratuity and pension, Lordship, at this stage, because in the meantime, he attained, 60 years has already gone, Lordship. Then the honorable division bench asked me to approach because there was no prayer in earlier writ petition. Therefore, I filed this writ petition for this. Now the government will not entertain me, Lordship, because after so long period, Lordship, and that is admitted the misconduct was there, Lordship.
So section 24 or rule 24 is not a matter of right.
It is
It is to be given only when there are deserving or special consideration.
That is I'm before Lordship.
Who will decide
My Lord will
that your
decide,
case is deserving or you ought to be
decide,
given
Lordship, but
special
because he
consideration?
served 13 years, Lordship, prior to this incident. That was a bad night, Lordship. And for that he has served.
You show me in your writ petition, what special grounds have you made in order to get the benefit of section 24
Lordship, I
or
have
rule 24?
Page number 10, para 8, Lordship. In entire writ petition, Lordship, I have said that
59 years old. That was in 2024.
24. Now he's 61, 62, around that, Lordship. It is almost like a mercy petition, Lordship. This is the only hope she has for survival.
You have not made out any case. You're just saying that there is rule 24,
Lordship.
which can be given to me.
Petition.
So, but rule 24 says that special consideration and deserving. How do we consider that in a writ petition? Your records speak otherwise. Conviction, dismissal.
Yes, that is admitted, Lordship. These are documentary proofs, Lordship. Convicted, he served, Lordship, but 13 years, prior to that 13 years, he served without any blemish. That is also there, Lordship.
You had no option. 13 years. Did you file criminal appeal?
During that appeal, he served the entire.
What do you mean by you served 13 years diligently without any complaint?
Yes,
It's a punishment given to you. If you're not happy with it, you have to file an appeal.
No, appeal, Lordship, during the appeal, petitioner sentence has already been over. So he,
No, for 13 years, you could not file appeal.
no, Lordship, prior to incident, he served for 13 years.
Prior to the incident means
The incident of the 376, Lordship.
he served 13 years in the police.
In the service, Lordship.
In jail, how many years did you serve?
5 years.
5 years. You didn't file an appeal.
Yes, Lordship, but during the pendency of the appeal, he served the entire sentence, Lordship.
Oh,
With
okay.
5 years only.
So you file, I think you must have filed appeal very late. Any affidavit filed?
Yes, we have filed affidavit.
They have filed, I also filed my rejoinder, Lord.
Lordship, can we see our affidavit ballots?
Yes.
Paragraph 4.
Respondent number 4.
Yeah.
By respondent number 4.
4, yeah, 4.
Who is respondent number 4?
Who is the minor?
Commandant.
Superintendent of police. Superintendent of police.
SP.
Disciplinary, yes.
Discipline, it
Page-
can't be allowed.
Page 95. 95 is the running page.
No, okay.
Paragraph 4. With regard to the statement made in paragraph 5, representation to answer the applicant state court, applicant was given a reasonable opportunity to make a representation against the defense case. And paragraph 7 is another. Then with regard to the statement made in 8, 9, 10, 11, this petition, the applicant states that as per rule 24 of the Assam, no person may be granted to an officer dismissal or removed from for misconduct, insolvency, and inefficiency, but to the officers who dismiss or remove, compassionate allowance may be granted where he is deserving for special consideration. So Lordship rightly point out what is her case, but there no case is better. In a instance case, the applicant who being a member of the disciplinary force was found guilty of a honorable court for a heinous crime involving moral turpitude. Moreover, there is no compassionate ground to be considered under special consideration for allowing the compassionate allowances to the appellant. Hence, no compassionate allowance can be granted to the appellant. This is the stand. So, crime is followed in 1998, both pass order, division 98. What is the explanation about the delay? Now, petitioner has come in 2026, 5/2/24. And what is the explanation? That was the division bench first page 77, watching the repetition time to see. Page 77. In view of the matter, the accused judgment or order cannot be sustained in law, is therefore interpreted. Considering the seriousness of the charges, remand the matter to the disciplinary authority to a deal of decision on the basis of the materials already on record, but strictly comply with the requirement of the rule. We make it clear that if on consideration of the issue, the disciplinary authority is inclined to hold that the charge against the appellant is established, it would undoubtedly provide an opportunity to him before the penalty. As the appellant is still dismissed from service from the year 1998, he dismissed from service in 1998. The exercise indicated herein above shall be completed with a period of 1 month from the date of receipt of the certificate. So petitioner was dismissed by the Department Authority, first Department, DP of 98. Now, from 98 now 26. So after more than 3 decades, without any explanation, he abruptly come to the court and saying that I am entitled for the benefits of a rule 24 of the pension rule. It is not a case that he has made out a special case that for which he is entitled for that. The rules does not provide him any ballot concession in this paragraph because there is no ballot exception in the rule. Had it been exception, it is different thing, ballot. Lordship in the rule ballot, may I read it? The rule, there is no exception. And by judicial interpretation, there cannot be a carve-out exception ballot. There is a rule ballot. The Supreme Court says. So, special consideration provided that the allowed gazetteer officer shall not be accepted. So, and what is the special consideration ballot? This special condition ballot, lordship, how lordship will decide it? There is no cases back or because the ballot statements of the petitioner in the petition does not reveal and does not say that there is special consideration for he is ballot direction is necessary to the authority to pay his ballot compassionate gratuity. So my humble submission, which your lordship, my lord, petitioner is dismissed from service and the fine 11 note that the petitioner was police personnel and he has been proved beyond reasonable doubt. And the judgment passing through under the petitioner, although the committed and a rape of a girl. And is crime is very hideous crime, but he rape is a girl, but who is deformed. Language means the physically from sorry, the girl's mother. So he raped it 2%. And last division bench order orders 3/5/2024, page 92. She says, my lord, taking note of the above contents of the learned counsel for the applicant, we have the view that prayer for compassionate pension was not there in the petition. The question cannot be considered at the appellate stage. The applicant, if so advised, can very well seek appropriate remedy for the relief before the appropriate forum. At this stage, learned counsel for the applicant has submitted that she wants to withdraw the intellectual application as well as the connected read appeal, and which is yet to be registered. So IA accordingly dismissed. So that is not clear in 2024, the division bench of High Court says. So petitioner ballot appropriate forum means to approach the government, not the court. His grievance may be ballot raised before the appropriate forum means government. Government can consider it or reject it, that is up to the government. So the affidavit filed by the SP, he is not a pure government matter, government is above it. She can go for appeal also, madam, and she has not preferred appeal. And more so, madam, 98, since 98, 2026, my lord, 36 years. After 36 years, without explanation, my lord, petitioner seeking my lord direction from this honorable court to pay his special consideration. Compassionate gratuity. The rule says only that can be of special consideration, reserving only the special consideration. A person who is convicted, he was jailed, and he is cannot be said by his special, there is no special consideration. What is he how to survive up to him? He is involved in a hideous crime, which is rape, like a physically handicapped guard. So there is no any scope for it, for granting any kind of compassionate case. And there is no direction from which Honorable Court to consider her case, his case under Rule 24 at all. The present repetition, my lord, the pair is my lord, only to give a direction. Give a direction to, yes, directing the respondent to pay compulsory allowances, pension, gratuity to the petitioner under as per Rule 24 of the Assam Service Pension Rule 96. And for this case is, well, that there is no statement that he is so and so for so and so, there is special reason that he should be provided. That nothing has been mentioned here in the petition. That's why the petition may be dismissed, my lord. And our affidavit is clear, and rules also clear.
So only respondent number 4 has filed. Yes, Ms. Kanungo, what do you say? You approach the government.
Regarding delay, lordship, delay was not there because
No.
lordship,
See, bottom line is that, like I already indicated, claim for this rule from benefit of Rule 24 is based on deserving and special consideration.
yes, lordship.
And in your writ petition, you have not stated anywhere that what are the special considerations which requires the attention. So you approach the state government,
Yes.
file your application before the Home Secretary for
If
consideration.
lordship has given that observation, then otherwise they will not allow me to submit anything, lordship. They will never, because I tried lordship, but they are not entertaining any
Where is
application.
the statement?
Statement is not there, lordship, because
Yeah,
he's
Mr.
afraid of,
Kanungo.
he's
You
afraid of,
cannot-
No representation, no statement.
no, lordship, he's afraid of, because lordship can imagine, he was out of touch from the department. That's why lordship, he denied to make any kind of such statement, lordship. Because
There's only two options. One is we dismiss the writ petition. Number two is that you approach the respondent authorities concerned, and for which you give your liberty to you.
if lordship,
Because this court cannot give any such kind of consideration.
lordship has given us that liberty to approach, that can,
The liberty is always there with you.
Yeah.
Why should you be given liberty? Nobody is stopping you. It is not even your case that you have gone there with 2 applications. Till today, they have not considered.
no,
You
application,
have,
they are
you have
not
straight away
entertaining,
come to the
lordship.
court saying, give me 24, Rule 24 benefit.
Application, they are not entertaining, lordship. That is their lordship. If
That is
lordship
not
makes,
there in your writ petition. This is your oral submission. How do we accept your oral submission? We'll reply back saying that you go and submit orally.
Maybe consider. If submitted, but maybe consider. We don't know. But direction is not necessary. Why, he said every case, court would direct, you go and file.
no, I'm not
You go
saying
and file it.
court may direct. I'm saying that court, if court has given me the
Okay, we'll
liberty
dispose it of by
At
giving
least
liberty,
to file an
liberty to
application.
approach the respondent.
Consideration,
Please
lordship.
listen to me.
Yes, yes.
Will dispose of by giving liberty to the petitioner to approach the respondent authority
That much.
with an observation that in the event such an application is filed within so and so time, the respondent authority will consider the same and take a decision within a time frame.
Yes, lordship, that can be done. Then petitioner
Please write
can.
hard Ms. S. Panungo, learned counsel for the petitioner, and Mr. T.C. Sutia, learned additional senior government advocate. Appearing for the state.
Yes, sir.
Senior government advocate.
Yes. Example, senior advocate and also additional senior government
okay.
advocate.
T.C. Sutia, learned senior counsel, and also senior government advocate, assisted by Miss
Soba.
Miss
Jay Sharma.
J. Sharma for the state respondents. Anybody else? No one. Having regard to the grievance projected by the petitioner, the same is taken up for disposal. Next brief history of the case is that the petitioner served as a police constable for about 13 years. And he was dismissed or removed?
Dismissed, Lordship.
He was dismissed from service on account of dismissed from service. After departmental inquiry was conducted against him. Stop. The petitioner filed 2 writ petitions and was not successful in getting any relief. Stop. Challenge made to the decision of the single judge before the division bench was made with an application for condonation of delay. Stop. However, where is that order?
Line, page number 91, 11, 92, 93, Lordship. Last 2 pages.
91, 92.
And single benches order 87 onwards.
However, the same was withdrawn, giving liberty to the petitioner to seek appropriate remedy before the appropriate forum for compassionate pension. Stop. That is how the petition is before this court, seeking grant of the reliefs available under Rule 24 of the Assam Services bracket pension, those bracket rules 1969. So Rule 24 provides that no pension may be granted to an officer dismissed or removed for misconduct, insolvency or efficiency, but to officers so dismissed or removed insolvency or inefficiency, okay, from after inefficiency put semicolon, but to officers so dismissed or removed, compassionate allowance and oblique or land compassionate gratuity may be granted when they are deserving of special consideration. Semicolon, provided that The allowance / gratuity granted to any officer shall not exceed 2/3 of the pension / gratuity, which would have been admissible to him if he had retired on medical certificate. Stop. The said benefit, in other words, may be granted when the same is deserving of special consideration. Next para. In the present case, it is not in dispute that the petitioner was convicted under section 376 IPC and had served a sentence of 5 years imprisonment. Apart from being dismissed from service. Stop. The writ petition otherwise does not contain any special grounds which requires consideration. Stop. Be that as it may, such special consideration in view of in the considered view of this court is a consideration which should be done by the employee based on relevant materials. So therefore, this court is not in position to undertake such consideration in absence of any special grounds provided in the writ petition. Stop. The respondent number 4, who is the superintendent of police, Caribbean law, had filed counter affidavit, but the other respondents have not filed any affidavit of opposition. So it also appears that the petitioner has not approached the state government with such for such relief. So accordingly, the writ petition is disposed of by giving liberty to the petitioner to approach the before whom you will file. Commissioner Secretary of Home Department. Before the liberty to the petitioner to approach the state government
Respondent number 1.
seeking appropriate relief Just read the sentence accordingly. State government, huh? The rest you cut. Seeking approach the state government, more particularly the respondent number 1. By filing appropriate application, if so advised, within a period of by filing appropriate application seeking the relief under section 24 under rule 24 of the Assam Services Pension Rules. Stop. In the event such application is filed within, when will you file?
Within 3 weeks, Lordship.
3 weeks.
2 weeks, Lordship.
In the event such an application is filed within a period of 15 days from today, the respondent number 1 shall duly consider the same in accordance with law and passed a reasoned and appropriate order. Of such an exercise should be done within a period of 6 weeks.
2 months, my lord. Because it will take some time, my lord.
Within a period of 2 months from the date of receipt of the representation. From the date of receipt of the representation of the petitioner, along with a certified copy of this order.
Deeply obliged.
Obliged.
It is a lot. Lordship, in this matter, last occasion, we were asked to produce the records and a specific instruction was sought for. That instruction is still awaited, Lordship. Instruction in regards how did we quantify the recoverable amount from the petitioner, Lordship. That specific instruction was sought for, Lordship, from this court. So we need some time to get that instruction, Lordship. Even the records, we have asked for the records, Lordship.
How much time do you require?
2 weeks, Lordship. In
2 weeks.
With the records plus a specific instruction, Lordship.
Last occasion, this records is available in soft copy. They had
Yep.
to print out it and produce.
The record for the hard copy, Lordship.
Okay. Mr.
R.R. Gogoi, Lordship.
R. Gogoi.
Forest Department.
Who are the respondent here?
For all the respondents, Lordship.
Who are they? Forest.
Forest Department.
You are standing counsel.
Standing counsel, Forest, Lordship.
Learned standing counsel, Forest Department, place for further 2 weeks' time to receive instructions and to produce the records. Terms of the court's order dated 37/2026. Praise the Lord. List again also.
Obliged.
Mr. S.D. Fukasta, learned counsel appears for the petitioner.
May please, Lordship. Matter pertains to my lord, family pension, my lord. Petitioner is there, my lord, first wife of the deceased, who was serving, my lord, as constable under my lord, Home and Political Department, my lord. And he died in harness on 5/5/2014, my lord.
Who died?
Husband of the petitioner, my lord.
He was the government servant.
Was the government servant serving as my lord constable under political and Home and Political Department, my lord.
When did he expire?
On 5/5/2014, my lord. And petitioner, liberal lordship, is the first wife, my lord. And respondent number 9, my lord, who claimed to be, my lord, second wife of the deceased, my lord. Respondent number 10, my lord. Private respondent, my lord.
Petitioner is the wife.
My lord.
Then respondent number 10 is the second wife.
My lord. Although under Hindu law, there is no concept of second wife, my lord.
Then
Now kindly see, my lord, page 41, my lord.
he died in harness or after?
Died in harness, my lord.
Died in harness. Anybody got pension?
No, my lord.
After he expired?
No, my lord.
Expired in 2014.
Yes, my lord. Nobody get, my lord, because
We're
respondent
in
number 10, my lord.
2026 now.
Respondent number 10 claim, my lord. But since I have filed complaint, my lord, before the authority, my lord, she got a NOK certificate, my lord. Because respondent
She
number
got
NOK certificate, next of kin certificate, my lord.
next of kin.
Yes, my lord. In her favor, my lord, without informing me, my lord. Then I have made a complaint, my lord. Kindly see page 41, my lord.
What about other benefits?
Nothing has been.
GIS, gratuity,
No
benefit.
No benefit, my lord.
So since 2014, nothing is given.
No, my lord.
Whether your husband is eligible for full pension?
Yes, my lord, pension. Yes.
How long is served?
That is not eligible, my lord, eligible. Kindly see, my lord, page 41, my lord. That is not in dispute, my lord.
That cannot be the answer. How long is served? Your answer is, it is not in dispute. What do you mean? You don't know the number of years you served?
Date of appointment, my lord, is not there, my lord. Kindly see page 41, my lord. Page 41, this is, my lord, issued by the, my lord, senior staff officer. With reference to subject, I am directed to enclose here with the copy of judgment of so-and-so, dated so-and-so, passed by the Honorable District and Sessions of Dhubri in connection with the claim of and counter claim by one Srimati Ashalata Odhikari is the petitioner, my lord. And Sri Jonaki Odhikari, who claimed to be the wives of late Constable so-and-so for your personal perusal and necessary action. In view of the above, you are requested to obtain fresh NOK certificate from the competent authority in respect of late so-and-so as to in the light of the content of the above judgment to enable this department to process family pension in favor of first wife of the deceased constable.
What is this judgment?
Yes, judgment is, my lord, kindly see.
What is it about?
Regarding, my lord, succession certificate, my lord.
You got the succession certificate.
No, that there was a, my lord, fact, my lord, page 34 is judgment, my lord.
Can you not sum up the facts of the case?
Yes. My lord, in that case, my lord, what happened, my lord? After petitioner filed the, my lord, case for succession certificate, my lord, and all evidences was adduced. Respondent number 10 also, my lord, appear. He also filed counter claim, my lord. But, my lord, before, my lord, pronouncement of judgment, the learned advocate, my lord, for the petitioner would do the, my lord, petition, my lord, for the petitioner, my lord. So ultimately, the court, my lord, could not issue the succession certificate, but there is a finding, my lord. The petitioner is the first wife, my lord. Operative portion, page 37, kindly see, my lord. Page 37 is the, my lord, operative portion, my lord.
Just wait a minute, okay?
Para 10,
Just a minute.
my lord.
Where is the judgment dated 17/7/2020?
Yes, page 34, kindly see. Page 34, my lord.
Who has filed this?
Petitioner file, my lord.
Name of the petitioner?
Ashalata Odhikari, my lord.
Miss SC number. What is the conclusion?
Yes, page 37, my lord. Page 37, para 10, my lord, sub-para, my lord.
Neither here nor there.
My lord.
You withdrew the succession certificate.
Yes, yes. But finding is that the petitioner is the first one, my lord. That finding is there, my lord. So to get the pension, my lord,
Why did you withdraw it?
I don't know, my lord. Petitioner is an elected person, my lord. Advocate, my lord, suggested him to have to do the petition case, my lord. She is an illiterate person, my lord. Petitioner, my lord.
Then why
Well,
did you file the succession certificate case in the first place if you want to withdraw it?
That was filed in the year 2014, my lord, and would done in just before the, my lord, passing the judgment, my lord. Evidence already evidence.
Although you are illiterate, you filed succession certificate.
Yes, my lord. Through advocate, my lord.
And because of illiteracy, again you withdrew it.
Through everything was done
And
through
you have not
advocate, my
taken any steps thereafter.
lord. No, my lord.
Yet you say that you give me pension.
Yes.
How they will give you pension?
Yes, now kindly see page 52, my lord.
Hmm?
Page 52, my lord.
Speaking order.
Yes, my lord.
On what?
After the dispute arose, my lord, the petitioner filed complaint. I have already mentioned page 49, my lord, 41, my lord. Seeking, my lord, fresh NOK. Thereafter, matter was inquired, my lord, by the, my lord, subdivisional magistrate, Dhubri, my lord.
Hmm?
This speaking order passed, my lord, after, my lord, giving opportunity to the petitioner as well as, my lord, respondent number 10, my lord. After hearing both the parties, this speaking order passed regarding issuance of fresh NOK certificate, my lord, for getting the pension, my lord.
NOK was issued to the respond number 10.
Yes, my lord.
Then you submitted complaint.
Yes, my lord.
Who has issued it? Who issued the NOK?
Petitioner residing at Dhubri, my lord.
Who issues NOK?
No, District Commissioner Nolbari, my lord.
So you complained before the district commissioner?
No, my lord. I complained before the authority under whose petitioner was serving, my lord.
Okay, then?
Then the authority, my lord, kindly see page 41.
You tell me what is,
Yes.
you don't, otherwise we'll see from page 1 to page 100.
Yes, the authorities.
It will take us whole day.
Then the
Page
authority,
1,
my
page
lord.
2, page 3. You
Yes.
tell me the story. What
Yes,
is the
sir.
story?
Then the authority, my lord, in the department, my lord,
Hmm.
sought fresh NOK certificate from the district commissioner Dhubri, my lord. Because, my lord,
You complained before the authority.
Yes, my lord.
Authority informed the
District Commissioner Dhubri, my lord,
to issue fresh NOK.
issue fresh NOK. Although the earlier NOK was issued by the district commissioner Nolbari, my lord.
Oh.
Fact remains that the deceased originally resident of Dhubri, my lord, permanent resident of Dhubri, my lord. But at the time of retirement, she was serving at Nolbari, my lord. So at the time of death, my lord, she was residing
How
at
can it
Nolbari.
be? One district will issue NOK, another district will issue another NOK.
That the authority returned to the district commissioner Dhubri, my lord.
Then
district commissioner Dhubri, my lord, issued notice to both the parties, my lord, petitioner as well as respondent 10. And after hearing, the speaking order was passed, my lord. Page 52, my lord.
What is the conclusion?
Conclusion is the petitioner is the first wife, my lord. So NOK certificate should be issued in favor of the petitioner, my lord.
And the earlier NOK cancelled?
Not cancelled, my lord. Then I have, my lord.
How many NOKs can be there?
Yes, I have filed additional affidavit bringing the earlier NOK, my lord, certificate.
Oh, that's okay. But what will happen after the speaking order?
Nothing was happened, my lord. Then, that is why
What is the purpose of having the speaking order then?
That is why I approached before your lordship, my lord. This speaking order never challenged by the respondent number 10. my lord.
May be issued. This is by the Dhubri. District
ma'am.
Commissioner.
Right.
Earlier NOK was by Nalbari.
Nalbari.
So what will happen to that?
I have met party, my lord, Nalbari district commission Nalbari met party, and NOK also, my lord. I have.
No, why didn't you apply for cancellation of the NOK before that Nalbari? District Commissioner.
Admittedly, petitioner is the, my lord, first wife, my lord. She will get the pension. And because of, my lord, the NOK certificate issued by the district commission Nalbari, my lord, petitioner is not getting, my lord.
Yes, respondents.
So for lordship, the respondent here in this case, lordship. So for the regarding lordship, pensionary benefit of the petitioner as well as the respondent. In our service record, which is maintained by the authority, it appears that the respondent is the private respondent is the sole wife of the deceased employee from the records, which is furnished by the deceased at the time of his in his lifetime. Record, I have the service record, original service record of the deceased husband of the petitioner as claimed. Now, lordship, in that dispute, without NOK, lordship, we are not in a position to proceed the the proposal of the pension in the name of the petitioner, lordship. At the same time, your lordship, regarding the NOK, lordship, so far the administration Gulukganj, so far the circle officer Gulukganj, wherein the petitioner approached for NOK, lordship. But earlier also I submitted the report of the circle officer, lordship, wherein wherein the office of the circle officer stated, lordship, that in the government notification, some bars are there, lordship. That 2 NOK cannot be issued, lordship. Therefore, the petitioner should challenge for cancellation of place for cancellation of the NOK, which is issued by the Nalbari, lordship.
Okay, who's appearing for the wife, second wife? You appearing first time?
No, earlier.
Have you filed affidavit?
Filed, ma'am.
You have filed affidavit?
I have filed.
Will this is for regular hearing? What to do?
Lordship,
This will take some time.
can it be sent for mediation? Can it be sent for mediation, lordship? If yes, lordship.
Mediation, how much certificate is required to cancel, my lord?
No.
So mediation cannot.
No. In the mediation, if both the wife will appear, both the claimed wife will appear in the before the mediator.
If they agree to share, it can be done.
Yes.
No, under, my lord, Hindu law, my lord. Second wife is
Everything
not
is there.
entitled, my lord.
Everything is there, but
Sharing of pension does not arise, my lord.
yes.
But what is the guarantee that you will get your share? According to the records, the second wife's
No,
name is there.
Second wife is met the nominee, my lord.
Correct.
Nominee is not, if the nominee is
in
violation of the legal judgment is there, my lord.
date of
Only similar.
yes. So from the date of it is not from the date of his service, lordship. Nowhere he stated regarding the name of the petitioner, lordship, as his wife during his lifetime, lordship. Therefore, the appropriate document is required. But the primary challenge before this court is that the petitioner is not challenged the NOK which is issued by the Nalbari, the office of the deputy commissioner Nalbari, lordship.
Now I have challenged, my lord. Through additional evidence is there, my
But
lord.
that first we have to sort out on that issue first.
Yes, I have filed additional evidence, my lord. Can you see, my lord?
No, you cannot challenge by additional affidavit. You have to amend the writ petition.
Yes. He should amend the repetition. The prayer is not there in the repetition.
You decide what to do. What do you want to do?
My proposal is that, lordship, if they will settle the matter before the mediator, lordship, then we are ready to process the pensionary benefit, release the pensionary benefit, but dispute should be settled first.
Okay, you think about it, we'll come back at two.
Minor.
What is to be done? Close.
What about?
We'll check that matter. Yes, so
Yes.
what have we decided?
Mediation, my lord.
Mediation.
All right. Parties are represented by the respective councils and they submit that the matter may be sent for mediation for an attempt to settle the matter. Next para, considering the submission, registry to place the same before the mediation cell for mediation without delay by notifying all the parties concerned.
Obligation. Respondent number one, lord.
Yes, respondent number one is present. Yes, madam.
Your Lordship, I'm Kavita Padmanabhan, Commissioner Secretary, Housing and Urban Affairs. I received a copy of the contempt notice just yesterday. So the moment I received the notice, I brought it to the notice of my counsel so that he could represent me this morning, Your Lordship.
Actually, you wanted to be present in person. That's why we insisted.
Yes, Your
There's an order and order, but the
Yeah.
manner in which the format was given, the notice was given to you was, and the choice was given to you perhaps, or
Yes.
by a council. That's why that thing is there. But if you read the order, the requirement was for you to appear here. So that is one thing. The other thing is regarding the compliance of the court's direction.
Your Lordship.
There's already an order passed,
Yes, Your Lordship.
and perhaps there is no appeal pending against that order.
No, Your Lordship, the
Uh.
direction was for the department to consider the application or the proposal that was sent by the Silchar Municipal Corporation. And we've received this proposal only on 7th of August by email. So now that we have received this particular proposal from Silchar Municipal Corporation, I'd like to assure you that we will expedite it immediately, Your Lordship. And I would also want to bring on record that I have been on childcare leave from December to March. And thereafter, somebody else was posted in my position as Senior Most Secretary of the department. I have resumed my responsibilities as Senior Most Secretary only on 23rd of June, once again, Your Lordship. So whenever these proceedings came up in the month of March, I was not aware of those and it was not brought to my notice as well since I was on leave in Delhi.
You are Kavita.
I'm Kavita
Padmanabhan.
Padmanabhan,
Okay.
Please respond number one.
respondent number one.
So now that you have received the proposal, how do you intend to go ahead with it?
Your Lordship, we'll examine the proposal. There is the proposal that has come from the Silchar Municipal Corporation talks of dues on two fronts. One is the arrears payment as well as the shortfall in terms of the salaries that has been received by the work charge employees. Once we receive this and we've examined it in toto, we will move it to the finance department for its consideration, Your Lordship, because currently we would also have to apportion for budget for this. So we will examine it and place it before the finance department at the earliest.
These are the dues, my lord, presently, my lord, pending. Madam, I'm also giving it. What I'm trying to apprise this court. What
How
I'm
many
trying-
employees are there in all?
In here it is 25, my lord.
25.
They are all grateful employees, my lord. So court has directed, my lord, in July 24 to pass arrear and current salaries. That also, my lord, the authorities are not in a position to pay it. July 24, my lord, people, all this, everybody is here, my lord. High-ranking officials, high-ranking judicial officers, your lordship is there. Despite this, my lord, these people are unable to get
a small order passed by this court at page 62. This is very unfortunate, my lord. My lord, yesterday when I was thinking how to implement this kind of orders, close the High Court for 1 week. Allow all these orders of the court to be followed.
Mr. Das, which is the operative portion of the
Page
judgment?
62, my lord.
Page 62, paragraph 30, Lordship. Lordship, kindly
The
see what
present
kind of
employer,
order or
namely,
prediction was issued, Lord.
yes, local urban employer, where all
Because the
coordination is
prediction,
necessary.
Consideration of the proposal to be forwarded by the Silchar Municipal Board. That was in accordance with law, Lord.
Mr. Naik, just a minute. Is it paragraph 30?
30, my lord. Your lordship will kindly read the paragraph in full and also page 86. Also page 86.
What is page 86?
Page 86, the municipal corporation's affidavit, a part of it, I'm just reading it last above. Your deponent state that Silchar Municipal Corporation, while letter dated 23, made a prayer before the Commissioner and Secretary to the Government of Assam for providing the grants in aid fund for Assam Urban Water Supply and Sewerage Board, Barak Valley. Deponent says already when a proposal was sent in the year 23, my lord. These are the employees of the, my lord, this housing urban affairs. Then they, by virtue of a particular decision of the government, they came back to Silchar, and now they are not getting their area salary, current salaries. Your lordship has passed the orders. It is more than 2 years. It has not been implemented.
This affidavit, this is a part of the affidavit?
Part of the affidavit. Filed by the municipal board.
Municipal board. Yes, madam, the affidavit says proposal was sent way back on 5/8.
Live up to our mark, my lord. We are very responsible persons. They are very grateful persons. We are unable to give them relief, my lord. All responsible officers are there. We are
No,
there.
but the direction
Why is
came,
that, man?
direction came in 24 only.
Yes, 24, 2 years.
Prior to
my
that,
lord.
there was a proposal.
Yes, prior to that, the
So
proposal.
now we are concerned with after the direction, what has been done.
Now, here, lord, sir, lord. Lord,
So-
kindly see.
Respondent number 1 has said that proposal is received on 7th of August. From the
Contempt has been committed, not by her or anybody, because the time period has lapsed. And I'll just read one judgment of the Madras High Court recently. I'll just read, my lord, your lordship will kindly see. It doesn't mean that if the period goes, my lord, it doesn't mean the contempt has been applied. I'll read this paragraph. Gone are those days when the very word contempt would send shivers down one's spine. I remember a senior counsel telling me some 20 years back that during his younger days, court halls used to be jam-packed during contempt proceedings because they were a rarity. Compliance was the norm, defiance an exception. He lamented about the increase in filing of contempt petitions. The situation is now worse. When ours is more worse, my lord. When Justice Bhattu Devanand was here, his lordship put the fear of God in the officials. Most of the judges would close the contempt petitions once they report compliance, even if belatedly done. Not so with Mr. Justice Bhattu Devanand. Even delayed compliance would not be condoned. Compliance must be strictly in consonance with the court's order. No deviation was permitted. Here, earliest means when a Supreme Court decision is there, not beyond 1 month. Your lordship will kindly see in what kind of place we are. Putting all these grateful officers, employees in such a difficult position.
See, we'll do one thing, we'll move forward since there is something.
Well, that is the only way, but.
So we would like you to file an affidavit within a certain period of time, showing the steps taken and what is the way forward.
My lord, what I pray, my lord, your lordship will kindly fix a date showing compliance report. That is the best way, my lord. Let them know, and file by file, it cannot go. Let them show compliance.
I would also like to say paragraph 29. In fact, they are employees engaged under a scheme. Initially, that scheme was
That has
run by
been
the
taken care
Swearage
of.
Board. That has been made clear by the learned single judge law. Subsequently, the scheme was handed over to the Silchar Municipal Board. And their salaries are to be paid from the earnings of the scheme, Lordship, not even from the Silchar Municipal Court. Court issued a direction, Lordship. We are examining the issue. But it is specific in the order that their salaries has to be paid from the, or whatever earnings is there from the scheme. It
All
is
right.
quite clear from
My
the
lord,
direction
Anand,
itself, Lordship.
I think my learned friend has not read the judgment properly, my lord.
All right,
Court has taken into consideration all these factors.
Okay. Respondent number 1 is there. Then what about number 2? Yes, what is?
Yesterday, she has got the information from some of the respondents of whom she got the disorder that have been balanced. Device, she, respondent number 1, she take a phone and do the need.
What happened on the last occasion? You were absent.
No, she is.
Why?
Lordship, in fact, what happened on last day, Lordship, the court was about to rise.
Yes.
We were online. And it was court was almost hounded, Lordship. And impression was given to the court that nobody is appearing on our behalf.
This is the thing.
In fact, Wakalatnama has already been filed. As it was a last matter, Lordship.
No,
probably-
question is on that day, who appeared? Who
That
all
is the
appeared?
question, Lordship. As it
You,
was a
had you
last-
appeared? Did you appear?
Nobody appeared on her behalf. That is the issue.
On behalf of the Social Corporation, I appeared,
Ah.
and I have informed them they have appeared for filing the vocation. So there, in spite of.
Okay.
that, it's passed. However,
Mr. Datta, you appear for which respondent?
This one was 6.
6.
Municipal
Okay,
Corporation.
okay.
However, we also can you say one thing, whether by filing a contempt petition, putting the officers in the jail, whether it will solve the problem. We have to see the root of the queen. What is happening? My lord, Suarez Court several is happening given to us.
No,
Now, if there is
Mr.
no-
Datta, see, those things we are aware about. You see,
It's
we
not-
take no pleasure. This court doesn't take any pleasure in asking the officers to come here. They have their own work.
No, Lordship.
But now the allegation is that non-compliance of the court's order.
Non-compliance is not
And
the allegation.
It is
Lordship.
because of that, this contempt petition is filed. And on the last occasion, an order has been passed for personal appearance. So that is why we are seeing where is the person concerned.
But that is
That is why
difficulty,
we are
Lordship.
here
As
at
it
2
was
o'clock.
The last item, Lordship, the court was about to rise, Lordship.
Maybe, I don't know what happened on that day. See,
Yes.
the matter was not before this court.
In regard to the personal appearance, I categorically informed that the council appeared
All
on
right.
behalf of the parties.
Some authorities are doing the needful, Lordship, because there is no such specific order to comply with the direction. Lordship, that is the last paragraph of the law.
And
You file your affidavit, Mr. Chaudhary, your client has to file affidavit. Why she has not come today?
Lordship,
All right.
She is presently at Jordan, Lordship.
Maybe,
Yes, Lordship, I will clarify that.
affidavit can be filed from anywhere. So what is the problem in not complying with the court's direction and not appearing before this court? You clarified an affidavit within a time frame. Please write. This contempt petition is filed alleging willful and deliberate non-compliance of the court's direction. Dated 26/7/2024. Stop, be it stated herein that the state order was passed in 3 writ petitions. And the present contempt petition is filed by the petitioners in WPC number 1989 of 2023. Stop, operative portion of the court's direction, which is at paragraph number 10, is abstracted hereunder. Page 62, K2A. Stop, in response to the contempt notice, in response to the notice issued to the respondents, who has filed affidavit?
So there's the respondent 6 filed.
Respondent number 6 has filed affidavit, whereas the others have not. Stop, when the matter was listed on 7/8/2026. Stop, apart from the learned senior counsel for the petitioner, Mr. S. Datta, learned senior counsel, for respondent number 6, as well as Mr. Chaliha, A. Chaliha, learned counsel for respondent numbers 4 were present. Stop this court, therefore, directed that the respondent number 1 and 2, respondent numbers 1 and 2 should appear in person on 11/8/2026. Stop. Today, Srimati Kavitha Padmanabhan, respondent number 1, is present in person, and she submits that a proposal was received from the Silchar Municipal Corporation only on 7th August 2026. Now further, she was on maternity leave, childcare leave, since December 2025, and joined back her position on 23/6/2026.
Can I?
Yes.
I resumed my duties on 23rd March, sir, but I resumed my responsibility as senior most secretary again of the department only on 23rd June, 2026.
Okay, resume our duties on 23rd March 2026, and then resumed our duty as the senior most secretary of the department concerned on 23rd of March, 23rd of June 2026. Stop. She submits that since the proposal has been received, they will be taking all necessary steps to process the matter so that the finance department can be approached, seeking their concurrence and for the fund that is required for payment of the area and current salaries of the employees concerned. Stop. Insofar as respondent number 2 is concerned, Mr. S.P. Chaudhary, learned counsel, submits that she is no longer holding the position of Managing Director of the Assam Urban Water Supply and Sewerage Board, but she is currently holding the post of Joint Secretary to the Government of Assam Health and Family Welfare Department. Where is she now? Charaidu? Where is Charaidu? How far? Stop. He further submits that she is currently in Charaidu and has received the notice of the court just in the late evening. Correct? When? When did she receive the notice?
She has not received the notice. She has been communicated by the other respondent.
And that she has not received any communication about personal appearance and has been informed verbally over phone by the other respondents. Next para, considering the above position, and having regard to the direction given by this court, the respondent number 1 shall file a detailed affidavit about the steps taken with regard to compliance of the court's direction within a period of.
Period has not been mentioned here. The lordship will not.
No. The affidavit.
Affidavit lordship within.
The steps taken.
Yes, affidavit lordship within 3 weeks time will file our affidavit. Or
Why
lordship will
3
make
weeks,
it 4
madam?
weeks lordship. Lordship, may I?
Not 3 weeks and unnecessary delay the matter now.
Lordship, in the court's direction, it was a direction, no positive direction is there. It is only a direction for consideration of the proposal to be sent by the censor municipal court. One
All
line,
right.
Lordship, has
All right, you
which
see-
expand the scope of the order.
No, you don't have to explain what has been passed by this court. What we are directing now is what steps has been taken in
Her
furtherance.
statement, only her statement, Lordship.
That's whatever steps have been taken, which is within our knowledge, power and possession, she will file that.
That is the affidavit is there, Lordship. The Lordship has recorded her statement now. There's no points. Lordship has recorded her statement that it will be sent for finance department concurrence. Lordship, it's a kind of presumption that they will concur, they will accept the proposal to be already sent by the future municipal court. They will consider, and if according to them it is okay, Lordship, they will send it to the finance department for their concurrence. But nowhere court directed that you have to pay that.
No, that's what she had said. That's what I've recorded.
Your Lordship, we will examine the proposal and thereafter send it to finance. But if the inference is that we will pay both the arrears as well as the current dues, then it becomes binding that I have given the impression that we are going to consider it in toto. So whatever is there as per due process and law, we will examine it and send it to finance for concurrence.
That's what I said.
All right.
That's what I said. What was the last line? Within a period of 2 weeks from today, such affidavit should be filed on or before 25th of, on or before 11. 26th of August 2026. Stop. Likewise, the respondent number 2 shall also file an affidavit as regards the difficulty faced by her in not appearing before this court today. And importantly, what steps had been taken in furtherance of the court's direction during her tenure in the post of
Managing Director, Assam Urban Water Supply Board.
Assam Managing Director, Assam Urban Water Supply and Sewerage Board. On or before 26th of August 2026. List the matter again on 26th of August 2026. The personal appearance of the respondent numbers 1 and 2 is dispensed for the time being. Yes.
Last order is there,
Lordship.
This is also, my lord, regarding salary payment.
No, Lordship, here in this case, Lordship, we already released 1,50,000 Lordship. And for other payment, Lordship, part payment, we propose for part payment, Lordship.
Okay, what is due? This due is regarding what?
My lord, your lordship will kindly see order dated
Towards-
37/26.
Yes, the due is towards
37, my lord, he retired in 2016, my lord. Employee of the corporation, he did not get some amount, so he had to file a petition. Very unfortunate part, 2016 he retired.
area
my lord.
salary and allowances.
Yes, my lord.
This is the amount.
Pending.
4,91,000.
Yes.
701.
Yes, yes.
1,50,000 already released, Lordship.
This is the state of our.
Why not the entire amount?
We submitted a proposal, Lordship, before your Lordship, that as per the earlier order, Lordship, we submitted one proposal before your Lordship, and accordingly, due to the financial hardship, Lordship, we are not.
They will have to
Financial
pay,
hardship faced by.
they will have to pay interest
The-
also on this.
The Borpeta Municipal Board, Municipal Board.
Okay, petitioner retired as what?
He retired as a tax collector.
Tax collector.
Yes.
So municipal board admits to the amount
Yes.
due to the petitioner,
Yes, Lordship. do
but
it.
only for
Yes,
want of the required fund.
Yes, Lordship. Therefore, Lordship, we make a schedule, Lordship, here in this case.
Lordship will let 12% interest on.
No, 12%, Lordship, that will.
Let it be 12%.
At this stage, Lordship, we.
My lord,
propose one
employee retired in the
schedule,
year
Lordship.
2016, my lord.
What is the bank rate, Mr. Das?
Bank rate is,
Now
my
7.5.
lord, personal loan interest is about 13-14%.
But deposit 7.5 Lordship. At
No,
this.
they are running a municipal board and keeping
Lordship.
this,
Also, kindly allow us that to, as per the.
with 10% interest. Let it
As
be
per the
approved.
proposal.
Given the proposal, a
Yes,
copy of this
Lordship,
proposal.
I also.
What do you say, Mr. Das?
It has gone up to 28.
Lordship is a condition of the municipal board.
No,
Lordship.
no, it is not acceptable, my lord. Let it come after 1 week or so. Let them come with a proper proposal.
No,
My lord,
Lordship,
this is 28, my lord.
No, Lordship.
2028.
Lordship, in a.
Let this
In a
executive
proposal-
officer's salary be stopped
No.
or the chairman's
No,
salary be stopped.
Chairman salary 5,000 only,
Only
sir.
that also, my lord.
Chairman salary is 5,000 only. Lord.
Chairman should not sign any check, my
No,
lord.
no.
Your lordship, that will take care of.
No, that.
How much he is signing, we know
Lordship,
about.
Lordship, the said board is trying to release the entire amount, Lordship. Therefore, 1,50,000 in a quantum, Lordship. in a-
Lordship will kindly see page 24, page 24.
See,
Lordship,
total amount is 4,91,000,
Yes,
correct?
already
It
one-
was, but it is
1,50,000
pending since 2016.
1,50,000
No,
already
just a
paid,
minute,
Lordship.
just a minute.
Yes.
4,91,000 is the amount figure
sir.
given in the prayer portion.
Yes.
And according to them, they have paid 1,50,000.
Lordship.
And what is the balance?
During
Lordship,
pendency.
3,41,701, Lordship.
3,41,000.
Yes, Lordship.
And you want to pay this amount in installments.
September, Lordship, 50,000. December 2026, 50,000. March
Mr.
2027.
Goswami, I'm seeing it here. You're giving the paper. You don't have to read it.
Lordship.
See, you want to give this amount
Lordship.
stretching from September 26 to March 2028.
Making a joke of everything, my lord. I don't know how they submit this proposal.
Every quarterly,
Lordship.
every quarterly.
Lordship, I will place before this honorable court that within 27, Lordship, we will complete, Lordship.
So you come with a proposal,
Yes, within 27 we will.
come with instruction.
No,
Because-
instruction, no,
because,
instruction. No,
See,
here, in
because
this-
we are going to record that.
Lordship.
You come with proper instructions, we'll
Lordship,
record that.
but here, Lordship, only one installment in 2028, Lordship, March. It is March, last one, serial number 7, Lordship.
Yes, I've seen it.
Yes, Lordship, therefore, Lordship, we will complete it within 27. I will give the proposal.
See, it is not that this entire amount comes in eight, 9 figures.
Lordship,
Okay.
It is the condition of the condition.
We
of the board,
understand,
Lordship,
we
financial
understand,
condition
but
of the
you cannot shake off your liability.
Lordship, it is
See.
the, Lordship, I do admit it. I have to due, Lordship. They are our employee, Lordship. And therefore, Lordship, considering the position of the present position of the board, Lordship, we are scheduling here in the installment basis, Lordship. Earlier, Lordship, one time we already paid 1,50,000, Lordship, one time. And others, Lordship, we will complete it within 27, Lordship.
So come with the instructions.
Yes, Lordship.
Written instructions. Mr. J.K.
Not
Goswami,
beyond 3 months, my lord. Beyond
J.K.
3 months.
Goswami, learned counsel for
12%
the
interest.
respondents, has produced a proposal given by the chairman, Barpeta Municipal Board, about as to how the balance amount of rupees 3,41,701 is to be paid to the petitioner. From a perusal of the proposal, it appears that an amount of rupees 50,000 is to be paid every quarterly, starting from the month of September 2026 up to the month of March 2028. So Mr. B.D. Das, Learned Senior Counsel, appearing for the petitioner, submits that the proposal is not acceptable since it has spilled over to the year 2028. of the petitioner, having retired, when did you retire?
2016, my lord.
Having retired in the year 2016, the respondent authorities concerned
January 16,
has
tax collector.
failed to pay him his dues. And he therefore submits that as specific direction may be issued to the respondents to pay the remaining dues along with interest.
He will
His-
apprise
his-
the bank interest.
his submission.
My lord, and he will apprise the bank interest. He will take information from his own bank. He will apprise the present, my lord, leviable.
Mr. J.K. Goswami, learned counsel submits that he may be given some more time to get further instructions from his clients. Praise the Lord. Release the matter again on.
After 1 week, my lord.
No,
It should
Lordship,
not go on, my lord.
Let's say that. Let him take his instructions. Let him. Huh?
It's 15 days, Lordship.
We'll fix a date. Give a date, please.
27, huh? Last week.
Second.
Yeah. 27, okay.
2nd September 2026, on which date the
29,
Mr. Goswami shall produce
29. 29.
his instructions.
Lordship, 2nd September.
Diploma.
Please, Lord. My lord, last occasion, my lord, record was called for.
Yes,
By order dated,
May I
my lord,
please?
27/5/2026.
I have received a record, Lordship, and going, some papers are in vernacular language, Lordship. Therefore, some clarification sought for from the department, Lordship. Some more time required, Lord.
Clarification or translation?
Translation and regarding some papers, clarification also required. 10 days time required, Lordship.
My lord. Miss B.
S.
S. Borwa, learned government advocate,
CGC.
learned CGC submits that although she has received the records,
Yes, Lord.
but she requires further clarification from the department concerned. And also translation of those documents which are in vernacular. So she therefore prays for 10 days, further 10 days time to produce the 11 records. Praise the Lord. List again.
8 miles,
Sir, 10
allowed,
days.
fixed. Diploma.
Yes, Mr. Weir.
My lord, the matter relates to selection and appointment as a Anganwadi worker, my lord. My lord, what has happened in this case, my lord, I had been working in the particular center as a Anganwadi worker, my lord, since the year 1997. My lord. Now, my lord, in the year 2024, the post of the Anganwadi worker, my lord, had fall vacant. Now, as per the my lord provision, there is a provision in the social welfare department that the post can be filled up by way of a promotion from Anganwadi helper to Anganwadi worker also. And to that effect, my lord, they have issued an advertisement also regarding my lord promotion of the eligible incumbents. And my lord may be pleased to find that advertisement also page number 20 of my petition, my lord. If my lord may be pleased to take up
You're challenging the final selection.
final selection, appointment, as well as, my lord, not considering my, my lord, promotion due to the, my lord, their contention is that,
Promotion,
my lord, actually the post had been filled up by promotion, not through direct recruitment, my lord, and for,
worker or helper?
from helper to worker, my lord.
Instruction awaited, Lord.
My lord. My lord, what has happened, my lord, in the meantime, promotion had also been effected and the private respondent had been promoted. Now, my lord, the difficulty is that, my lord, the contention which they have raised is that, my lord, I am overaged pursuant to a, my lord, notification of the department, my lord. And if, my lord, that notification is also a part of my writ petition, my lord, may be pleased to find.
Okay, anyway, let them file affidavit.
Yes, Lord. My lord,
Yes,
but
ma'am.
the, my lord, one important query had been raised, my lord, in this issue,
that the, my lord, for that also instruction had been sought for by my lordships, my lord.
Yes, what is that?
And that query was, my lord, that regarding the notification by which the age had been extended to 50 years, my lord. Earlier it was 45. The person, the Anganwadi worker, my lord, helper who were working, my lord, should not exceed the age 45 years, then
Okay.
only they are eligible for promotion.
Private respondent is more than 50, more than 45.
No, my lord, she is less than 45. No, private respondent. Huh? No, we are, my lord, above 45 years of age. That's why we had been rejected, my lord. But the private respondent not.
She's younger than 45.
45, my lord.
Lesser than 45.
So therefore,
You
my
are
lord,
more than 45.
more than 45.
So
Now,
So you should produce that. There's a.
yes,
there's
yes, my lord, that
notification
notification.
For relaxation.
My lord, I am just, my lord, bringing my lordship's kind attention to a page, my lord, 36 of my writ petition, my lord. Dated 22nd of August 2025. This says, my lord, that in partial modification of the notification number dated 4th March 2013, the serial number 6 of the guideline be substituted as follows. The Anganwadi helper to be eligible for promotion under this scheme shall not be above 50 years of age at the time of consideration of her case for promotion. So, my lord, by way of this notification, I am eligible, my lord. Now,
You have not crossed 50
no.
at the time of consideration.
My lord, now I am 46 years, my lord.
So
So
you're
therefore,
46.
yes, my lord. So therefore, on the strength of this notification, my lordships wanted to know from the department that how this notification can be applied in my case, my lord. So in their affidavit, my lord, this instruction is also required, my lord.
So they'll file because this is a part of your writ petition.
Part of my writ petition.
Mr. Goswami, when you will file affidavit?
After 2 weeks time is required.
Okay. As paid for by Mr. J.K. Goswami.
Affidavit দেবো
Learned Counsel. Learned State Council. Further 2 weeks time is granted. To file counter affidavit list again on so and so.
My lord. Obliged, my lord.
Anyone?
Yes. Nice.
Herein the issue is, your lordship, the candidature of the petitioner was rejected on the ground of certain deformities, your lordship. Initial stage, your lordship, in the medical examination, he was found 3 deformities, your lordship. One
What
is
this?
hyper,
What a selection is this?
regarding Central Armed Police Force, your lordship.
KPF.
Yes.
You were not selected.
In medical, your lordship, he has been rejected, your lordship.
Medically, you're rejected.
Yes.
Review board.
Yes. Page 47, your lordship, kindly have a look.
What is the ground?
Page 47, your lordship. Sorry, 48. The petitioner, in initial medical board, your lordship, the petitioner was found 4 dental point, which is less than 14, and hypertension and carrying angle, your lordship. And thereafter, review medical was done. In the review medical, only 2 deformities were found. That is 4 dental point and hypertension, your lordship. And when the petitioner was examined by the Gauhati, the Regional Dental College, Gauhati, your lordship, page 50, your
You
lordship.
don't have a typed copy of this. How do we read this?
90. Okay. That could be a cynic person.
Some point at artificial dental. What is this? Then
Yes,
hypertension.
yeah. But in here, the ground, they have stated that the petitioner has 4 dental point, your lordship, which is less than 14. And the second ground is that he was found hypertension, your lordship. These 2 grounds, your lordship, they have cited in this, in page 48. But in fact, your lordship, the petitioner, he was examined by page 50, your lordship, kindly have a look. In initial medical examination, he was found 3 deformities.
No, before that, tell me where have you written down that page 48? You should type it out. Difficult to read, see. Grounds for rejection.
But the lordship can also.
Come to page
I
7,
have
para 6.
stated,
Page 7, para 6.
yes.
Where is that?
Page 7, para 6. I'm reading the para 6, your lordship. Thereafter, the petitioner appeared before the review medical examination too. For his review medical examination, the petitioner was diagnosed and subsequently.
not here, it's not here. This is paragraph 5.
Lordship, the RME board has illegally held that the blood pressure is found as 160/92 first days and 156/90 second days, and further it has held that the dental point is also less than 40. So
Dental point, come to page 6. Paragraph 5, dental point less than 14. Then second one is hypertension and carrying angle greater than 20 degrees in left hand.
the carrying angle, your lordship, in subsequently when he was in RME board, your lordship, that deformity was not found. Only two there was, one is the hypertension, another one is the dental point, your lordship.
DME is the first.
Yes,
DME is the first.
yes.
Out there, they found dental point less than 14, then hypertension and carrying angle greater than 20 degrees in left hand. Anything else?
No,
Only these two deformity.
yes, only these two deformities in the RME board.
Then in
But
the
regarding that issue, your lordship, the petitioner, he was examined.
what happened in the review?
Page 50, your lordship, kindly have a look.
No, we can't read what is written here. You should have, I told you how
Which
many
one?
times?
Which
It should have been typed.
all?
Come to paragraph 6. Where have you stated the findings of the review medical board?
Para 6, your lordship, this is the finding.
Illegally held blood pressure is found at 160/92.
First day,
First day, then
156/90 second day.
second day.
And further, it has been held that the dental point is also less than 14.
Okay. Dental point is less than 14.
Yes.
But dental point was less than 14 in the DME also.
In the DME also, it was 14. And
There's nothing mentioned about the angle
no. Angle is not there here.
left hand. It's
Yes.
not there.
In the
So now
RM
basically it is the fluctuation of your BP
yes,
and your
dental point.
dental point.
Yes.
Then now you want to say that you had gone to what?
In the
GMCH?
yes, in the regional dental college, Gauhati, your lordship, he was examined. The petition.
Page 50.
Yes, page 50 and page 50. And the next page is given, your lordship. Dental point is 14. And
What is dental point here?
dental point, it means the number of the teeth, your lordship.
Huh?
Number.
What is the difference from the DME
page-
RME?
In page 50, your lordship, kindly see that dental points, your lordship, how it was calculated, your lordship. In the bottom part, your lordship, it has given. In page 50, in the bottom part, it has given how it was calculated.
We are not expert. We don't know what is what. Dental point 14 means what?
Yes, as per our medical guideline, lordship, dental point explaining in the medical point, come to my affidavit, lordship. Page 72. This is start from page 66. Guideline for recruitment, medical examination in Central Armed Police Force and Assam Rifles. This is guideline. On the basis of this guideline, review medical board or DME or RME were conducted. Let's say, and as this according to this guideline, page 71, general grounds for rejection. That is, their hypertension is there. and he was detected hypertension. He was admitted in the Patgaon BSF hospital, and hypertension regularly monitoring the petitioner, and hypertension was found fluctuate. And after that comes to page 72.
Madam,
Yes,
what I wanted to know was somebody to explain, what do you mean by this dental point?
dental point, that is in page 72, Lordship. Calculation of dental point.
Does it mean that he has got less tooth than what
14.
a person should have? Total count of your,
Count your lordship less than 14, because
Yes,
the
sir.
guideline says that your lordship, it should be 14.
14.
And their calculation is, it is less,
14 upper jaw or lower jaw?
including
Into-
upper and lower. Your-
Upper and lower.
Yes.
Lordship,
It is less than 14.
Yes,
So minimum is 14.
minimum is the 14.
If you possess less than 14, you are not
Then he
fit.
is eligible.
Okay.
Person.
So say that, that's what I was asking.
he was found below
Ah.
14. Lordship.
So in both RME as well as in the
DME.
PM,
Yes, Lordship.
PME, DME and RME,
And he-
both less than 14.
Yes, Lordship.
Now today he says that he went to the regional dental institute,
Yes,
and
Lordship.
what is the result?
The result is, your lordship, they have found that it is 14, your lordship.
From where you got additional one?
Page 50, your lordship.
Before DME, RME, it was not there. Before the,
Therefore, only, your lordship, this petition
Huh?
we have filed because of the arbitrary action on the part of the RME board. Because they have, in the affidavit also, your lordship will see, those such documents they have annexed along with their affidavit.
no, you see, the doctors were there, the dentists were there, physically on the spot to count your teeth. From the court, how do we count your teeth?
No, it is
And-
the exponential.
In the regional dental college, what is the finding?
The finding is, your lordship, the next page, your lordship, 50A, your lordship, the next page, your lordship. Dental point is 14. And how it is calculated, your lordship, that is given in page 14, in bottom part. Page 50, bottom part, your lordship, how
Hmm.
dental points are calculated, your lordship, that has been given in page 50, bottom. In further advice, your lordship, in
So how much do you have? 15?
14, your lordship, it is equal to 40.
4, 5, 6, 7, 8, 9, 10, 11, 12, 13.
14.
No, third molar. Third molar is how much? Three
Yes.
numbers.
In here, your lordship, incisory given 4,
Yes,
canine 2,
then
premolar, your lordship,
2,
premolar is 2, second premolar is 1,
9,
first molar is 0, second molar is 2,
then
third
11,
molar is 3. Altogether,
12, 13,
your
14.
lordship, 40.
4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Okay.
But the guideline, what says, your lordship, I'm just
So
reading
that
guide-
14th tooth which was missing now has appeared again.
Yes, Lordship, as per our guideline, 14 should be there, Lordship.
So 14 is there as per our regional dental.
As per our
Okay.
affidavit, Lordship, he was examined by the doctors, and review medical board performed and dental points, and petitioner was admitted BSF hospital, and expert after after that, going through he was found below 14. We have stated in our affidavit, Lordship, and record also there, Lordship, but as per our guideline, their incisors should be 4, canine should be 2, premolar should be 4, and molar should be 6.
Molar should be
6.
6.
Dental- Yeah, no, yeah, Lordship.
Please take me to that.
Page 73, here. How it is calculated is, it is described here, Lordship.
Lordship,
Point
herein I just want to
73.
read out the
Page-
guideline.
page-
Just a minute, don't interrupt. Page 73, incisors 4,
Yes, for Roman 1, 2, and
canine 2.
explains about-
Canine is 2. Then 3 molars. Premolar is only 2. Molars 6. Mr. Counsel, for the petitioner, see if you compare page 50 with page 73, CGC says that page 73 is the prescription. So insofar as premolar is concerned, there is deficiency. And premolar and molars. Premolar requirement is 4, molar is 6. You have only two each.
Lordship, I just want to read out the guideline, Your Lordship, what the guideline says, Your Lordship.
Yes, where?
Yes, the guideline is with me, Your Lordship. I will hand over it, Your Lordship. A candidate will be accepted. Extra copies? Yes. Fourteen.
But this is only molar. What about your BP? You have got fluctuating BP.
Yes, Lordship, that is also, he was admitted in the BSF Patgao, Lordship, and BP monitoring as per.
Lordship, I am reading, Your Lordship, the relevant. It is the guideline, Your Lordship. This is the guideline regarding dental point, Your Lordship. A candidate will be accepted. Your Lordship, got it?
Read.
A candidate will be accepted provided there are at least 14 dental points.
Yes.
That para, Your Lordship.
That much.
So a candidate will be accepted provided there are at least 14 dental points in his her mouth, and all these teeth must be sound or repairable. Thus, the minimum number of the points required in a candidate will be 14.
And calculation is given in the.
So it says that, Your Lordship, a candidate is required to hold 14 dental points, Your Lordship. The candidate who has possessed 14 is qualified, Your Lordship.
And the calculation is there
But
also.
the calculation, Your Lordship, regarding
The chart is there.
No, chart is there, Your Lordship, but it says that the 14 number is required, Your Lordship.
14 number is required, Lordship, but explanation is given on top of the Roman 2. 2, 1, 2, 3, 4, 5, and 6. How calculated? 1 point. Teeth which are not considered necessary for efficient mastication are allotted 1 point. Each and those essential 2.6.
So how do we decide by way of this writ petition?
But here
They say you require 14. You say you have 14. But again, there's another provision here which says that what kind of the number of types of teeth that you should have. Incisors, canine, premolars, and molars. This has been again provided. It might so happen that it might so happen that in some of your teeth, incisors, there is double growth.
But chart is there, Your Lordship. I'm not.
Supposing you have double growth.
Yes.
It happens, isn't it? Double growth.
Yes.
Growing over one another. So total you have calculated 14. That will not be sufficient. It has to be precisely as per this chart. Incisors 4, canine 2, premolars 4, molars 6. The same guidelines which you are using, you are relying upon.
But herein, Your Lordship, what I'm praying is that, Your Lordship, one chance, Your Lordship, may kindly be given to the petitioner for further examination, Your Lordship. We have, Your Lordship, that means the petitioner herein, we have filed this petition merely because that arbitrarily his enlisted has been rejected. It is apparent from the report of the Dental College of Gauhati, Your Lordship. Therefore, only, Your Lordship, I am praying for allowing the petitioner
Maybe,
to.
but Lordship, for armed forces.
You allow him to complete, you allow him to complete. Both of you are interrupting each other. So we don't know the story, it's half incomplete. Half the story you are narrating, another story she's narrating.
My whole case is that, your lordship, his candidature has been illegally rejected because of the page 50, your lordship. The page 50 says that he has 14 data points, but the review in their affidavit also, they have not supported any documents on the basis of which the petitioner was found doing 14 data points.
But Mr. Counsel, you must have heard me what I said. Merely having 14 does not make you qualify. You should have incisors 4 quantities. Canine 2, premolars 4, molars 6 as per the chart. You have deficiency in the premolar. You have only 2, whereas requirement is 4.
But the guideline says that, your lordship, there are at least 14 dental points. At least 14 dental points. Table is there, your lordship. I am admitting that fact, your lordship. Table is there, but here there are at least 14 dental points, your lordship. What I mean is that, your lordship, the 14 dental point is required, your lordship.
Then apart from your dental problems, what about
next?
what about your blood pressure?
Blood pressure, your lordship.
How much should you have? Normal. What is the normal blood pressure?
The normal blood pressure as per guideline, your lordship, it is 140 by 100, your lordship.
Huh?
The guideline says that.
140 by 100?
Yes.
I don't think so. That is abnormal.
Lordship, kindly have a look. Page 38 or
No, normal BP is 120 by 80.
page 38, your lordship, kindly.
Huh?
Page 38. Examination of blood pressure, your lordship. The normal range. Yes.
Guideline.
Yes. 38, your lordship. Examination of blood pressure, normal range, systolic 100 to 140 mm. Page 38, your lordship. But this doesn't, I'm reading.
How much was your BP?
BP
156 and 160 on the higher side.
160 by 92, your lordship.
Candidates, please just a minute. Candidates should not be rejected on the basis of single high reading. In cases of blood pressure is recorded to be higher than 140 mm, systolic and or 90 mm diastolic. At least 2 more recordings should be taken in lying position at an interval of 2 to 3 hours before declaring him unfit. You were measured on 2 days, first day, second day, correct?
Yes.
First day 160 by 92, second day 156 by 90. You have exceeded both. How do you say it was illegally, you were illegally rejected?
And regarding the BP, your lordship, it pays 50 on your lordship of my petition.
Huh?
File. Pays 50 on your lordship.
51. What is there in 51? Again, you are normal.
In 51 normal, your lordship.
You were so nervous on the date of your test, your BP became high. After you went outside, you became normal, like that.
129/11,
Hmm?
it was 120.
How much? 125.
128/87
Where is that?
in page 51, Your Lordship.
Right and left. R and L means right and left. Both hands.
Both hands, Your Lordship.
R is right, left,
Yes,
L is
and
left.
L is left, Your Lordship. 125/85.
So how do we proceed? In two medical examination, you fail. Again, if you go to the Gauhati Medical College, you pass. So how do we proceed?
And page 53 also, Your Lordship.
Hmm?
Page 53, 54. These are regarding the BP, Your Lordship.
When was this taken? This BP? Date? November 29, 2025.
RME was done on 24/11/2025, and on 29/11/2025, it was before the Gauhati Medical College, Your Lordship. The blood pressure was measured at Gauhati Medical College. And 53, 54, Your Lordship, these are the government hospital.
No, review was done on 24/11.
Yes,
Then you went to the GMCH on 29/11.
yes.
And you found your blood pressure to be normal.
No.
He was admitted in the hospital, Lordship, and monitored and found BP abnormal, Lordship. I attend
He
report.
was admitted. When? When?
Yes, he was admitted in the
When?
during the period of RME, review medical.
Where have you stated that?
Yes, we have stated in our 58 page number of our affidavit, Lordship.
58.
Yes, Lordship, paragraph 5. Paragraph 5.
Yes. Please read.
That with regard to the statement made in paragraph 6 of the petition, the answering deponent humbly submits that the petitioner was afforded an opportunity to apply for review medical examination. The petitioner availed the said opportunity and reported 19/11/25. The review medical board performed orthopantogram OPZ for dental points, and petitioner was admitted BSF Hospital, CHBSF Patna for BP monitoring as per recruitment guideline of CAPS. During admission, the petitioner's blood pressure was found to higher than the prescribed limit on multiple times. The OPZ again revealed dental points 14. Minimum points required are 14 of the petitioner.
During admission means when?
During admission, when for BP monitoring.
The date. The date. On which date?
Date
He reported on 19/11. When was he admitted? And up till when? Why I'm asking you is because the review was done on 24/11.
24/11, the report was
6 days.
3 days in 2 days he was admitted for 2 days. One thing.
5 days after he reported, review was done. He reported on 19/11,
When he
review done on 24/11. And when was he admitted? You have not given the date.
Date.
So we don't know when he was admitted.
Record may be called for, Lordship. In some other matters, we have bringing the record of.
Bring the records.
But herein we have filed the affidavit, Your Lordship. No such document, Your Lordship, they have annexed. Regarding.
Please write the petitioner, by filing this writ petition, claims that he has been wrongly ousted from the recruitment process to the post of constable GD, CAPF. On account of his blood pressure not being normal and his dental point being less than 14. Stop. When the petitioner went for dental examination before the regional dental college and for checking his blood pressure in the Gauhati Medical College and Hospital, he was found to be eligible to be considered for appointment to the post of constable. Stop. Although the respondents have filed a counter affidavit, this court would like to peruse the relevant records pertaining to the examination of the petitioner in the detailed medical examination and in the review medical examination board. Garnet CGC, Miss So-and-so shall produce the records by the next date. List again on
In September.
records will come from where?
September
From what?
3.
From?
Patgaon. 3. September 3.
Patgaon, Guwahati.
Patgaon. Where is Patgaon?
Patgaon, Guwahati.
Hazara.
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 So
September.
why?
After 10 days, Lordship. 29.
Okay, make it 3rd September. 3rd September.
Oblate.
Mr. Fatgiri, what is this?
My lord, selection and appointment of the constable, my lord.
Same thing, constable, CPM. What is the problem here now?
Problem, my lord, the petitioner passed all the, my lord, criteria, my lord, and thereafter, my lord, select list was published. And those petitioner got more mark than the last selected candidate, my lord. Then, my lord, I approached before this honorable court, and thereafter, my lord, respondent filed affidavit stating that, my lord, my EWS certificate was, my lord, defective one.
Which was certificate?
EWS,
EWS,
my lord,
economically weaker section.
my lord. And my lord, can see, my lord, EWS certificate, my lord,
Page?
is, my lord, 134. Affidavit filed by the respondent, my lord. Yeah, the certificate, my lord, valid for the year 24-25.
This is filed by whom?
My lord, affidavit filed by the, my lord, respondent, my lord, 4, 7, and 8,
They've enclosed it in their affidavit.
my lord.
So what is defective according to them?
Defective, my lord, stating that, my lord, it is, my lord, last, my lord, for the financial year 24-25. It ought to have been 23-24, my lord. And that's why, my lord, EWS, my lord, the category has not been considered, and, my lord, secretly converted the candidature to the unreserved category, my lord.
Then after conversion, what happens?
But after conversion, my lord, I have get lesser mark than the last cut-off mark, my lord, under unreserved category, my lord. And it is the defective
EWS is one category.
my lord.
You have the SC, ST, OBC.
I am the general category, my lord.
You are from the general,
General, my lord.
but belong to that EWS.
My lord.
So some cutoff marks are different
Different, my lord.
for EWS.
My lord.
Now, the only problem is that the year for which it was issued, according to them, is not correct.
My lord.
It should have been 2023, 2024.
2024, my lord. And subsequently,
And the recruitment was happened in which year?
my lord, 26, my lord.
Okay, where is the prescription like that? CGC?
Yes, Lordship.
And subsequently, my lord,
Page number 30, 31 of the petition, Lordship.
Advertisement.
Page number 30.
This is a part of the advertisement,
Petition, Lordship.
advertisement,
Yes,
That is
Lordship.
condition.
30,
Yes, Lordship.
plus
Clause 6.5.
6.5.
The crucial date for a claim of ST, SC, ST, OBC, EWS status or any other benefit, that is fees, concession, reservation, age relaxation, etc. will be the closing date for receipt of the online application from 14/10/24. Then come to 6.7, page 31, Lordship. A person seeking appointment on the basis of reservation to EWS must ensure the possess the income asset certificate valid for the financial year 24/25 issued on the basis of income for the financial year 23/24 in accordance with the so and so dated 31/1/19. And he's produced the EWS certificate that is not valid for 23/24 months. That is valid for 24/25 and issued on 24/25. He annexed with his certificate, two certificate he has annexed with the writ petition, Lordship. Both are, one is annexed in page 23.
Page
23. This is valid for 24/25 and for the financial year 24/25. And another is annexed in page number 24. That is valid for 25/26 and financial year 24/25. Both are not according to the notification advertisement.
After knowing
At
the
the time of
defect, my lord, I approached before the my lord, the issuing authority, my lord, and the issuing authority, my lord, I filed with affidavit in reply and rectified the same, my lord. Kindly see, my lord, 142, my lord, of my affidavit in reply. I think that it is inadvertent typological and clerical error. While stating that, my lord. My contention was that, my lord, due to my lord defective certificate, my lord, my candidature cannot be rejected, my lord.
May I please one thing, Lordship? This clarification annexure B of affidavit in reply,
I
it
have
is signed by circle officer, Lordship. And this OBC EWS certificate was signed by assistant commissioner.
Same authority, my lord,
No, Lordship.
revenue authority, my lord.
No,
Issued.
Lordship, circle office, this is issued by the assistant commissioner. Circle officer cannot clarify, how can he clarify?
Page 24 is by circle officer.
24 is not, 24 is the in format, Lordship.
It
That's
is also
this-
24 is a circle officer, my lord.
24 is regarding
24 my lord, subsequent year, my lord. Valid for the year 25/26, my lord. And
correct.
23
But see, the issuing authority is the circle officer.
circle officer.
Page 23 again, it's the
Is
the assistant commissioner.
He is relying upon annexure, this is 23, page 23.
My lord, is the assistant of the bus shield, my lord, it is circle officer, my lord. Assistant commissioner may also, my lord, in charge of the circle officer also, my lord. At that point of time, my lord.
At the time of document verification, it was rejected, Lordship. After that, and the post basic converted to the general category, Lordship.
No
How
notice
can
was
now,
issued, my lord, and subsequently my lord, appeared for medical, my lord, medical declared fit, my lord. And while the, my lord, select list was published, my lord, cut off mark published, then I got know that, my lord, that defect, my lord.
Okay, Assistant Commissioner is Bongaigaon
Bongaigaon, my lord.
and this Circle Officer is
Under the
Manipur,
Bongaigaon district, under the Bongaigaon, my lord.
under Bongaigaon.
Bongaigaon.
You had submitted this? Or what?
My lord,
The corrigendum,
corrigendum.
you submitted?
My lord, I have annexed before this honorable court, my lord. Because, my lord, during pendency of the writ petition, my lord.
No, here you have annexed, but you have not submitted before the authority.
No.
So how will they know?
Recently, my lord, it was at 11/6/2026, my lord. And result declared was 15/1/2026, my lord. 15/1. Respondent ought to have, my lord, noticed about this defect, my lord, at the time of document verification, my lord. They secretly converted my candidates are under the unreserved category. And thereafter, after filing, my lord.
What is there to be secretly? See,
My lord,
now, if you don't have the EWS certificate, the valid one,
my lord.
you belong to the general category, automatically you will be considered amongst the general. Benefit of EWS can be availed if we have that valid
They have
EWS.
submitted, my lord, to validate-
According to them, it was not valid, that's why.
My lord.
So there is no question of secretly taking you down to general category. Isn't it? If it's not as per the prescription in the advertisement, then they have every right to reject it. Typographical mistake committed is a different thing altogether. But there's nothing secret about it.
It is, my lord, defective certificate, it may be cured, my lord.
You could have cured it at the relevant time.
Then, my lord,
At this stage, how do you cure it?
Recruitment process is over and all the posters filled.
one post, my lord, by interim order, but one post get taken, my lord.
Huh? Okay, one post has been kept vacant.
My citation of, my lord, the Delhi High Court, my lord.
What does it say?
That, my lord, candidate cannot be rejected on the ground of defective certificate.
On the ground of
Defective certificate.
defective certificate.
Paragraph 3 is the argument and 9 is the, my lord.
How do you say on facts this is applicable to your case?
Because
It was produced before the last date.
paragraph number 11,
Yes.
similarly, in the light of the above order, it is held that production of certificate in any event subject to its verification by the respondent, the petitioner's application are entitled to be further processed. Similarly, the production of the acceptable format of the OBC certificate in Anil Kumar case also merit considered on his candidature and further processing subject to verification.
Was produced before the last stage of selection process. In your case, that is not the case.
That is different, Lordship, he produced.
But and my argument, in paragraph number 3, the production of a defective certificate or one which does not conform the preordinate format is at best an irregularity which can be set right or cured by the candidate and cannot be a ground for disqualification. Learned Counsel states that not being possessed an education qualification amount to disqualification, whereas being possessed the defective caste certificate or defective date of birth or record which does not conform to the format in respect of date of birth would be mere irregularities which are curable. In any event, the authorities can verify the correct state of affairs and production of the correct and acceptable documentation on the later date. This would not mean that candidate acquires that status belonging to the OBC, ST and SC, ST later. I am admittedly, EWS, but due to some mistake done by the issuing authority, I cannot be deprived, for that reason,
How do you say it's a mistake? When did you apply for it?
Within time, as per 6.5, clause 6.1 page 30. The crucial therefore claim of STOC, EWS status or any other benefits under the election will be at the closing date of the receipt of the online application from 14/10/2024.
Come to page 134. Yes. When did you apply?
Issued on 29/2024.
26/9, is it?
22/09/2024.
29. There's one more certificate somewhere in the writ, in the writ petition.
But it is not a issue. Issue is but that issuing authority wrongly stated the financial year 23/24, 24/25. On that ground, it was rejected.
When do you count the financial year?
I have also annexed my lord page 41, my lord. In the regarding my lord 23-24, my lord.
No, please try to understand the query I'm making. See, the purpose of giving this certificate is regarding your economical status,
Status, my lord.
saying that your gross annual income is below 8 lakhs. Annual income of which year?
My lord.
Tell me, of which year?
My lord,
As per this certificate.
simultaneously, my lord, I have also, my lord, submitted the income certificate of my father, my lord, of my family, my lord.
That is not the question. Please answer my question. This certificate, when was it issued?
9.
20 September 2024.
24.
And it says it is for the financial year 2024-2025.
Yes, it is right, Lordship.
How is it right?
Financial year start from April to March March, Lordship.
So where is the financial year ending for this year?
Is September.
No,
Is 24.
financial ending will be on March 2025.
25.
Yes, Lordship.
Correct?
Therefore, is financial year 24-25.
No, that is not the issue. I'm asking you about the date on which it was issued. Today, can you issue a certificate saying that your 8 lakhs income is, you have 8 lakhs income
Yes.
for this financial year up till next year, March 2025? In future, how do you know? It has to be 1 year ahead.
My lord.
Now your financial statement will be from 2020.
1 year ahead, my lord.
Huh.
My lord.
Now we're in 2026, isn't it? 24, 25.
My lord. 24 for the financial 23-24.
So
It was wrongly done by the issuing authority, my lord.
So they could not have anticipated that till March next year you will get only your income will be on 8 lakhs. You never know. It may be lesser also. So what I'm saying is that admittedly there has been some mistake.
By the issuing authority, my lord. Not
It
by
appears.
fault,
It appears.
my lord. Not by fault, my lord.
Going by the date of issuance.
My lord. I made also, my lord, deputy commissioner as the party, my lord. If necessary, my lord, verified, my lord, whether by EW status on that financial is exist or not, my lord.
So on this point, perhaps there might be some consideration.
My lord.
But authenticity of this certificate submitted by the
Had it been issued in the year 2025, I don't think belatedly you come up another. You can rectify. You go to the authority, please rectify. They'll issue another one. That is not acceptable. But here they have even given a certificate in advance. Till next year, your income will be only 8 lakhs. He is not Nostradamus to predict he'll get only 8 lakhs rupees till next year. That is not possible. So apparently there's some mistake here. Was this the only ground on which you had failed?
On that ground, my lord, converted to the unreserved category. If considered, my lord, as EWS category, then, my lord, I obviously, my lord, accounted, my lord. In, my lord, BSF, CISF, and CRPF, my lord. After passing of the all segment, my lord, it is, my lord, document verification, thereafter medical, my lord. My lord, at the time of document verification, my lord, it should have, my lord, notice to the given notice to the, my lord, petitioner, my lord, regarding rejection on that ground, my lord. But respondent has not given, my lord.
Is it necessary?
not necessary.
There'll be thousands of candidates. 8,000 candidates rejected. Everyone will get one letter. This is the reason for rejection. Not possible.
Before this honorable.
Not possible. They'll just put a
list, selected candidate, this is a select list.
Their candidates has been rejected, my lord. And they were for medical examination, my lord. But in the case of the petitioner, my lord, I also passed the medically, my lord, finally, my lord. And after declaring the result, I came to know that, my lord, my candidature is, my lord, considered as unreserved category, my lord. And it is, my lord,
So, madam, can we dispose it off? There's nothing else to do. We have heard you.
From district commissioner, district commissioner is made a party lordship in this petition. From district commissioner, one clarification sought for in this regard, the mistake, by mistake occurred. Whether it is
correct or not, my lord.
yes, lordship,
This-
this is
Made a
authentic.
deputy commissioner, my lord, as a party, my lord.
Deputy commissioner is party. Yeah.
Respondent number 9, my lord.
Who is appearing for the deputy commissioner, district commissioner? No one appeared earlier.
Earlier appearing.
Who appeared?
Also may appear also, my lord, from my lord.
You are also appearing.
I cannot, yes, I can, but A. Chakraborty's name was
Whose name?
on A. Chakraborty.
M. Bhattacharjee also was there.
Yes, that's. Instruction not received from government side. That's.
Why they are not appearing?
Today, he is there.
Everyone is in a hurry today. What happened? There is something. Some more interesting thing outside.
I informed that's it.
You inform. Please write. Hard Mr. K.R. Patgiri, learned counsel for the petitioner, and Miss S. Borwa,
For CGC.
learned CGC, for respondent numbers 1 to 8. No one appears for respondent number 9. That is the district commissioner, Bongaigaon. Although Miss M. Bhattacharjee, learned additional senior government advocate, had appeared on 18/2/2026. Next para. Grievance of the petitioner is that his candidature for the post of constable in the Central Armed Police Forces have been rejected. By putting him in the general category, although he belongs to the economically weaker section of the general category. Stop. The petitioner contends that the ground for rejecting his EWS certificate is that the same was shown to be for the financial year 2024-2025, whereas it should have been for the year 2023-2024. Stop. The learned counsel submits that it is only due to certain clerical mistake that the financial year has been wrongly indicated. So the petitioner has obtained a corrigendum from the competent authority showing that there was a clerical mistake and the same should have been for the financial year 2023-2024. Stop. The learned CGC, however, disputes the issuance of the corrigendum by the circle officer, Manikpur Revenue Circle, since the earlier issuing authority was the Assistant Commissioner, Bongaigaon. Stop. Mr. K.R. Patgiri, learned counsel, submits that
Manipur Revenue Circle is a revenue circle under the Bongaigaon district. And the circle officer is competent to issue such certificates. Stop. Another aspect of the matter which has drawn the attention of this court is that the EWS certificate, which was not accepted by the respondent authorities, was issued on 29/2024 for the financial year 2024-2025. Stop. It therefore appears that the certificate was issued in advance even before the financial year ending of 2024-2025. Stop. It therefore appears that the petitioner perhaps might have a case subject to a verification about the acceptability of the corrigendum issued by the circle officer of Manipur Revenue Circle. Annexed as annexure B to the rejoinder affidavit filed by the petitioner. Bracket page 142. Next para. Since the learned state counsel is absent today, learned CGC shall inform the learned state counsel to receive instructions in this regard by the next date. State counsel, whose name will record?
A Chakraborty will maybe.
State counsel, Mr. A. Chakraborty.
Just he was.
You want Chakraborty or you want the?
So dear,
You take one name. M. Bhattacharjee also had appeared last time.
J.K. Goswami maybe. Ne.
J.K. Goswami.
Yes.
Will inform Mr. J.K. Goswami, learned government advocate, to obtain instructions in this regard. List the matter again on so and so.
For hearing, I think 22.
This was item number 15.
My lord, before a lordship takes up the hearing matter, my lord, I have
That item, yes. What was that?
28 and 29, my lord. I'm for the respondent ONGC, but unfortunately, a mention was made in the morning without informing me. With that in may, my lord, I don't have any issue, but the lordship may report my presence for the matters.
Yes, Chakraborty.
Yes, ma'am.
Please take note of that. Huh? Item 28, 29. There was an order dictated in the morning seeking adjournment. We just write Mr. S. Chakraborty, learned counsel, APS 4 respondent number 10.
ONGC. ONGC. I'm representing in ONGC in both the matters.
Item 28, 29.
Yes, ma'am.
You are Mr. Chakraborty, isn't it?
Yes, yes. I'm S. Chakraborty.
It says R10.
R10 is one of the respondents, but ONGC is a party. Anyway, my lordship will record ONGC.
Okay. APS for the respondent of NGC. Huh? Just check up and who has taken the dictation. Okay. You make the corrections, okay? Fine. Okay. Hearing matter.
Your lordship, kindly adjourn the matter for 3 weeks. My senior counsel, Mr. Raju Goswami's son, has been expired.
Who? Whose son? R. Goswami.
Goswami.
Oh. It is submitted at the bar that the Mr. R. Goswami, learned counsel for the appellant, is in bereavement, and therefore matter be adjourned for 3 weeks.
Justice, I am for the respondent here. This
Your
matter
good
is
name?
All pending matter here.
Your good name?
Amar Islam,
Mr. Amar Islam,
respondent now.
learned counsel, appears for respondent number 1, submits that he has no objection to the prayer, but submits that since this is a pending matter, a date may be fixed. Accordingly,
Short date may be.
see, you have heard the reason why. So these are natural things, you cannot help it. This is the matter on 8/9/2026 for hearing.
Hello.
Okay?
Obliged.
Shall continue. Item number 15.
Or the last one, huh? Interim order partially shall continue till the next date of listing.
Obliged.
I'm appealing for the respondent lawsuit. This is regarding removal from service due to aforesaid lawsuit.
Removal from service.
Removal from service lawsuit. He was on leave for 20 days. Thereafter, he never joined the duty lawsuit.
Okay, last time court was informed that the counsel for the petitioner has undergone surgery.
Lawsuit.
Probably is not recovered.
Lawsuit. But yesterday I have seen most probably he has recovered lawsuit. Is it?
A. Bhattacharya.
Yeah, but,
You have seen him
yes, not today lawsuit.
yesterday.
Yesterday.
He was there yesterday. Yeah. None appears for the petitioner. The matter is called. Stop. However, Miss A. Devi, learned CGC, appears for the respondents.
Otherwise, also lordship, this repetition is not maintainable lordship. Earlier they have the same order, they challenge the in the other.
Mr. Goswami, one matter today we had done. What is the item number? 15. Item 15. You have to take instructions. Your friend will tell you. Okay. Regarding that circle officers authorized, I mean, whether he's competent to issue certificate or not, that much only. Okay. But the other side is absent. We cannot pass order. This is a 2018 matter. And therefore, no, before that you write like this. For the ends of justice, the matter stands adjourned to be listed again when? On 10 September 2026. Stop, since this is an old pending matter, it is expected that the petitioner will be represented by the next date, failing which court may consider passing appropriate order.
25.
My lord, it's a whole pending matter, otherwise, but I'm told that CGCC is absent today.
Who is the counsel?
This is A guy, your lordship.
A. Gayan. What happened?
For some personal difficulties, your lordship.
Personal difficulty. What is the issue, Mr. Pathak?
First of all, it's a 2020 matter, my lord. The issue was, my lord, discharged from service because of earning rating entry, my lord.
Because of?
Rating entry, my lord. In service, they mark, my lord.
Red ink entry.
My lord. For my cases of minor indiscipline, my lord.
Okay,
they
where?
mark you a rating, my lord.
You
This
belong?
serving in Assam, right?
Assam reference.
then, my lord, if you accumulate a number of reading entries, my lord, it can lead to discharge.
I
But
see.
when the law is otherwise settled, that, my lord, the incidents that happen has to show that you are a habitual offender. The same kind of offense has to be repeated again and again, so that the conclusion of that you are incorrigible has to be drawn. And secondly, my lord, there's a procedural violation that even if case you, my lord, have earned reading entries, the discharge is not automatic. There has to be a proceeding drawn. And there has to be a finding, my lord, as to
2020
how-
matter. Are you still interested?
Yes, my lord.
Are you still interested to go back to service?
My lord, definitely.
By now, you must be doing something else. Anyway, we'll fix a date.
Because this, otherwise, both these issues are already well settled, my lord. Recently, our
Uh,
High Court has also settled this 107
Please write,
and 108
although
proceedings.
Mr. B. Pathak, Learned Counsel for the petition is present, a prayer for adjournment has been sought on behalf of Ms. A. Gayan, Learned CGC, by Ms.
M. Burman.
M.
Burman.
Borman, on the ground that she has some personal difficulty to appear before the court today. And therefore, prays for another date. Stop having regard to the fact that the matter is of the year 2020. The parties concerned should not seek adjournment. Hereafter. List the matter again on 10th September for hearing.
It's otherwise, I think 39 years in age, so therefore he is interested.
39 years.
Age is still is on his side.
Okay. That is why he's getting so much of red. So was quite active.
Quite active, my lord.
Okay.
Item 30.
May I please, your lordship? Your lordship, this matter pertains to your lordship, the unauthorized absence for a period of 715 days, your lordship. On account of your lordship, that I was unauthorizedly absent, your lordship, there was an absent report that was being prepared, your lordship. In the year 2017, your lordship. What has happened, your lordship, that in the year 2015, your lordship, from 13 to 2015, till your lordship,
Why were you absent for more than almost 2 years?
yes,
What happened?
your lordship.
Why were you absent for about 2 years?
That is the whole, your lordship, the
There is no reason.
that have been made, your lordship. I was, first of all, your lordship, I had suffered pressure stroke, your lordship. And I was granted 120 days of earned leave, your lordship, from,
What are you? What were you?
your lordship, unarmed branch constable, your lordship.
Constable in the police force.
Yes.
So you have to maintain discipline
Yes, your lordship, I have maintained discipline, your lordship. What has happened?
by being absent for 2 years.
Your lordship, in the inquiry proceedings, your lordship, the absent report that was been prepared, your lordship, there has been no substantiation with respect to attendance register that has to be maintained with respect to unarmed branch constable under the Assam Police Manual rule, your lordship. In the inquiry report finding itself, your lordship, while conducting the inquiry, the prosecution witnesses have stated that, yes, I was shown to be present in the police reserve disposition, and under whose supervision I was up to discharge my duty. None of them had particularly categorically stated that I was absent, your lordship. Now, after a period of 15 days, there was this absent report being prepared without maintaining the attendance register. If a person,
Where were you posted?
your lordship,
Where were you posted at that time?
I was posted at Nagaon, your lordship. So,
And they don't maintain the register.
yes, your lordship, that is also the particular plea that I
No,
have taken
you were
here.
posted in Nagaon and doing as what?
Yes, your lordship, as an
Precisely where? Orderly.
orderly room personal, your lordship, as an unarmed branch constable, your lordship.
No, you were assigned duties to where? Where were you assigned?
I was shown to be present at the police reserve disposition, where my duties were attached, particularly at the office of the superintendent, your lordship, Nagaon district, your lordship, as an unarmed branch constable.
You were attached to the office of the SP.
Superintendent of police, yes, sir.
SP Nogam.
Yes, your lordship.
So they don't maintain any attendance register.
Yes, your lordship, and as per rule 15 of the Assam Police Manual, your lordship, part 3, your lordship, there is a particular requirement from the office of the superintendent, your lordship, to maintain the attendance register. If there has been an attendance register maintained, your lordship, the hour of arrival, the hour of departure, and the particular day's absence are to be recorded. Your
All right, all right. What is the penalty imposed upon you?
Your lordship, dismissal from service prior to 1 month before retirement of my services. Your lordship.
Dismissal,
Yes, your lordship.
dismissal. After DP?
Yes, your lordship.
Okay. So you produce the records, we'll see.
Lordship,
Lordship,
the
records have been produced, lordship.
yes, the record is in process. Lordship, first of all, Lordship, so far, this is the departmental proceeding. After, this is the departmental proceeding, Lordship. After due procedure of the departmental proceeding, this was initiated, findings were made by the inquiry officer, and second so cause was sent to him, the petitioner. Petitioner retaliate to the second so cause notice, and thereafter, after obtaining the reply from the second so cause notice, Lordship, the authority passed the impugn order for dismissal. After that, the petitioner approached before the appellated authority. Appellated authority disposed of the matter and dismissed his appeal, Lordship. Now he is before this honorable court, Lordship. Now, so far regarding the non-maintainability of the non-maintenance of the non-maintenance of the record of absent, Lordship, that was not initiated during his proceeding, Lordship. Neither second so cause notice, neither in appeal is a fresh plea.
No, your lordship.
No, just a minute. I will.
Yes.
Is a fresh plea which is taken before this, before your lordship. Lordship, at the same time, what happened, Lordship? The inquiry officer, when he conducted the inquiry, he was never assert in his cross-examination also whether the presenting officer to the presenting officer or the witnesses authority.
In short,
Yes.
the stand taken by him today
Lordship,
is for the
during
first time.
Yes, during the inquiry, Lordship, this stand has not been taken. Rather than, Lordship, in 41, page 41, in his written statement to the second so cause notice, he categorically admitted his absence.
Okay. So that's why you produce the records. Yeah, why I'm saying is because your affidavit is only about how many pages?
Yes, your lordship.
3 pages. This is not sufficient.
And your lordship.
You produce the records.
Yes, Lordship.
Now, who has filed the affidavit?
Your lordship, the respondent number 4, your lordship.
Who's number 4?
The office of the superintendent of police, your lordship, the appointing authority as well.
The officer has filed, not the SP.
Yes, perhaps the
Huh?
SPS 5 here. Respondent 5, your lordship.
Who's respondent number 4?
Respondent number 4 is the Inspector General, Lordship.
Your lordship, the plea of having not maintained the attendance register was taken during the.
We'll see in
At
due
page
course.
59, your lordship.
Number 4 is IGP, CR. What is CR? Crime.
Lordship, one affidavit is necessary from respondent 5, Lordship. Is the SP, now it is SSP, Lordship.
And that plea was already being taken, your lordship. If your lordship has a perusal of page number 39, your lordship, of the reply to the second so clause, I have particularly mentioned, your lordship, that there was no maintenance of register, your lordship. Even the fact remains, your lordship, if the medical circumstances were compelling, the absence of an employee has to be, your lordship, to the willful disobedience of the authorities, your lordship. Because of attending medical circumstances, even if there has been an absence, your lordship, that absence would not account for an unauthorized absence, your lordship. There has been a well-settled principles of law that.
There's a well-settled principle also that a person from the armed forces,
Yes, your lordship.
absence without authority is viewed very seriously.
Yes, Lordship.
Because you belong to the discipline force.
Because the fact that there has been no maintenance of attendance register, your lordship.
We'll see about that. We'll see about that when the records are produced.
Your lordship stated that I was absent. There has no such indication to the fact, your lordship.
I will.
Inspector General of Police has filed.
No, Lordship, SSP on behalf of the SSP, Lordship, it is a respondent 5, Lordship, one affidavit is required, Lordship.
Now at the hearing stage, your
No,
lordship.
affidavit.
At the hearing stage.
What affidavit for what?
Lordship, to
You produce the records.
Yes, I will produce the record.
What affidavit can you file?
Yes, regarding.
Affidavit has to be filed from the records only.
No,
Yes,
Lordship, regarding the maintenance of the registered, Lordship. That part is, we are not, retaliate in that part, Lordship. That part is.
It's okay, we'll
It's a
keep it
fresh part,
open.
Lordship.
We'll keep it open. Just bring the records. When can you bring the records?
May I submit your lordship? On the last occasion, your lordship may very well produce the last order, your lordship, order dated, your lordship. If your lordship produces order dated 28/7/2026, records have already been produced and they sought the time to peruse the records, your lordship.
Yes, you have the records
Yeah, Lordship, record is here, Lordship.
with you.
Lordship,
You have it with you.
Lordship, record is in my office, Lordship. Lordship, at the same time, Lordship, what happened, Lordship? In the last occasion, Lordship, so far regarding the new point. it
I've
was
understood.
raised.
Why you are still lingering on that point? I've already understood that point.
Yes,
We'll keep it open.
Lordship.
Okay, but you produce the records because the affidavit is only 3 pages.
Yes, I will produce, Lordship. I will produce.
There's nothing-
one by
nothing-
one bill, Lordship.
When will you produce?
Lordship, in the next week, any day.
27/8.
Your lordship, 22.
Hmm?
Prior to 1 month's retirement of my services, your lordship, I was dismissed from the service.
What to do? You must have done something.
I'm unauthorized absence, your lordship, there has to be willful disobedience, your
But if you only say that you were absent for 715 days only.
Your lordship, that is the whole allegation. Because of non-maintenance of the attendance register and my presence at the duty, I was not allotted.
Can we have it 2 days ahead? List again on 25/8/2026. Learned, Mr. J.K. Goswami, Learned State Council shall produce the relevant records regarding to the department proceeding drawn against the petitioner. Uh, uh, The Learned Counsel for the petitioner has also submitted that the respondent authorities have failed to maintain the register, which would otherwise indicate whether the petitioner was absent or present. Stop. To this, Mr. J.K. Goswami, Learned State Council, submits that this submission or this stand has been taken for the first time. It was never the case of the petitioner during the department proceeding.
Yes.
Be that as it may, the same will be considered at the relevant time. List accordingly.
My name may be recorded, D.S. Dekha.
D.S. Dekha, yes, definitely. Mr. D.S. Dekha, Learned Counsel appears for the petitioner. Hmm.
This matter will require some hearing.
You are there? What is the matter?
So the matter-
Termination.
Lordship, I was a superintendent of tax
Ah.
in the Assam government. Lordship, I was discharged from my services and my appeal was also not allowed. And then sitting over appeal in that matter. That is why I filed this petition.
Okay, we have a date then. Readings are complete otherwise. Parties are represented by the respective councils and they submit that the pleadings are complete. However, due to positive time, matter cannot be taken up today. Accordingly, list the matter. When? 15/9, on 15/9 for hearing.
Much obliged, Lord.